Good morning, everyone. Welcome to the room and virtually. Hi there. Hi. And so, well, I'm going to do the usual roll call, and we'll just see who's out there. Folks, help me figure out who's online, and we'll just get a sense of who's in the room. Okay, Senator Washington, probably in session. Okay, as Delegate Stewart, probably in session also. I see to keep them updated. Okay, I am here. I was actually may have had to have shown up jury duty this morning, which I'm grateful for. Theo is here. Lori, did I see Lori? Lori out there? Anywhere?
I saw Laura.
Good morning, I'm here.
There you are. Hi.
Hello.
Amy.
Good morning.
Laura, there you are. James just walked in. We are good. Councilman, are you out there, Councilman Hobb?
He said he may or may not be here today. He called me yesterday.
Okay.
I'm showing up late.
Okay, David, you are up here. Okay, Tiffany. Tiffany Harris, here you are here.
I had a message from her this morning. I didn't have time to read the whole thing, but she's not.
Okay, Quinn Griffith, are you out there?
Good morning.
There you are, Quinn. Thank you. Nebulo. Krista.
Here, good
There
morning.
you are. Hi.
Online today.
Thank you. Priscilla. Priscilla, are you out there? Anyone out there from AFC?
Yeah, I'm joining also. Fami here.
I'm
also
sorry.
joining.
I'm sorry. What's your name again?
Fami, and then
From our staff.
She's ours with us.
Yeah.
Oh, sorry, intern.
There's Priscilla.
Oh, sorry, not AARP. Oh, there's Priscilla. Okay. Sorry, it's confusing me here. Mandy. I see Mandy. Yes, you're here, Mandy. Jennifer is here. And Chelsea? Are you on the?
Chelsea has been switched out with Lisa Bell
Okay, that did not get updated. Lisa, are you out there? Okay. And Isabella? Nope. Isabella, are you out there? Okay. Great. Wonderful. We have so much to get through today. I was reviewing the agenda and there's a lot to do, and we are kind of on the home stretch here, gang, but it's probably going to be the most intensive couple of months ahead of us to get to that home stretch and get the report done. I know I am the proud kind of mother of this lovely staff, but they have been working so hard, and every time I start reviewing all the materials and realize what's going in here, I'm just just really proud of everything that's been getting produced. So we'll talk about it later in the agenda. We're gonna have to really crunch to get ready for that April meeting to make sure we come out of that one, and we'll talk about that a little bit more later. But let's go ahead, Joe, and go through the agenda. I should have the update. So yeah, we're gonna break it down. Obviously, I'm gonna try to keep us on time as best as possible. Obviously, we'll always still have our public comment. No presentations, no panels today. So
Correct.
just us, right?
Correct.
So gonna be trying to encourage dialogue, discussion, input on those spots where we need that along the way. And we'll get you all out of here at 12:30. We have a few treats, so feel free, and I'll probably just get a feel like usual of the good break point. Take a little quick break somewhere in between like we usually do. So with that, I think we're gonna move into, I'm gonna try to ensure we have time at the end too. So I usually do this, the closing round. So if there's things that you're kind of thinking as we go, or things that, please, feel free to include that in our closing round. I think it's always a good way to kind of sum up how the day or the meeting went. So our objectives today, Joe has them up here for us, pretty much aligned with the agenda, but we've got quite a bit to prepare for. The research, obviously, figure out where we're at, what we're hearing. It's almost overwhelming. There's just so many disparate parts to how ADUs are being handled, not only in our state, but across the country. The legislative recommendations, specific to utilities and fees, is our focus today.
Correct.
The best practices in terms of local governments around those utilities and fees, and prepare for April. I want to make sure we really think about I mean, we've got ideas, but want to get your thoughts and input on how we best make use of that time. So that when we leave that meeting, we'll be in a good place to hopefully finalize at our main meeting. Joe, anything else to add on the objectives here?
No, we will have public comment. I would say the preparation for April 16th, we do have a whole section at the end, but that's going to be kind of interspersed throughout of this. So I would like to be thinking about that throughout.
I think that's.
And then, yeah, we have a lot, the first one, I know we have Adam Snyder here to share some insight with us, and we just want to give you an update on the research we've been doing, the work towards the report. Part of the report was included in the agenda packet, which will, discussion of that will inform what we do on the 16th.
Great, okay, well, then next slide, public comment, obviously we'll be doing that at the end. Towards the end anyways, we've scheduled 12 o'clock, so we'll try to hit that mark to make sure we have a public comment time frame. So anybody who's out there in the public or joining us, know that that's going to be a good point at which we will switch to public comment. Shut the meeting. And then obviously the online is really helpful way to do it because we file all those online comments too. So next slide. Okay, I'm going to turn it over to Joe.
Thank you.
Take us through the parking.
Thank you, Secretary Flora. So yeah, last month's February 20th, we discussed parking in community facilities. So I added those before I get into the details. So I just want to clarify if there's any confusion on the task force part that I sent you that document in late February. That was the recommendations document on which you can copy. It's in the, or on which you can comment. It's in the team site. So that's a Word document and had the notes on the side. You could put track changes. I sent that email requesting, how I'd like you to provide feedback on it. So I still encourage you to comment on that, especially as we're working towards the April 16th meeting. That document is separate from the one that I sent, the PDF I sent as an agenda packet, because the one I sent you did not include these recommendations. So I just want to make sure there's no confusion there. So that one that I asked you for comments on includes all the compiled recommendations we've developed over the preceding topics, but it did not include these. I will, after this meeting, I will be adding these ones that were in the PDF I sent you to that Microsoft Teams document on which you can comment. Okay.
I'm gonna, Joe, as it relates to April, I'm just gonna recommend for myself and possibly for others, you each will have your own system, but block some time on your calendar now. Just know that we're gonna have to really go through individually all of these things that have been compiling. So we've read them all before that April meeting. And I would say, Joe, we'll probably have, like, you're gonna be adding this. Is this gonna be the last, or the environmental survey still has yet to be added probably in terms of our information?
I'll go over the environmental survey. So I still have to add today's batch of recommendations we developed for utilities and fees will be the last topical batch that I'll add to this, to the recommendations document. I mean, these are already included, but then I'll add that one. And then, so those are the ones we're going to be prioritizing by April 16th. But I'm going to go over this a little bit later. There's a number of topics that have come up that we've talked about that don't fit neatly into the topical structure we've set. So we're going to need to discuss those on April 16th as well. And we do have an extra hour for that meeting. I'll go over some of those topics.
Yeah, I think the main thing is we're gonna, work with the team on this, but I think we're gonna really try to make sure we have everything in your hands. At least 2 weeks in advance. So you have plenty of time. I know we're scrambling to try to get your materials, but I think we're gonna really shoot that those, particularly the recommendations document, are fully filled in and ready for you to start reviewing at least 2 weeks in advance. So today's going to be the other big batch. Okay, I'm sorry.
It's okay.
Okay.
All right, so regarding parking in community facilities, I'm not gonna read the whole screen. You'll see more detail in the document I sent you. But for local governments, the recommendations are to have parking in our community facilities requirements to facilitate rather than intentionally limit ADUs or even unintentionally limit ADUs. You all talked about the importance of context sensitivity regarding transit, proximity to transit, neighborhood context, and average lot size. we discussed that adequate public facilities ordinance should treat ADUs differently because they do not generate as many school-aged children. We're going to look at some examples of that today. There's a lot of overlap with the fees discussion that we're going to have today and the examples with what we talked about last week in community facilities, because a lot of those fees go towards community facilities. Regarding state government, we talked about how the state should incentivize ADU ordinances that are responsive to TOD context, transit-oriented development context, or proximity to transit, to disincentivize requiring more than one off-street parking space. We talked a lot about one being a common requirement. And we didn't all agree on whether or not that should be advisable, but we definitely strongly said that there should be no more than one required. And that the state should develop guidance on maximum parking standards, APFOs, and the relationship to ADUs, and the actual infrastructure and facilities impacts that ADUs have presented, those that have been developed in Merrill. Regarding best practices, we discussed a lot of this is overlapping with the local government examples earlier, but variability by zoning district or neighborhood context. So not having parking requirements if it's proximate to transit, if there's sufficient curb area, and if there are higher levels of impervious surface or smaller lot areas, right? We talked about how if you have an objective or goal or desire to limit impervious surface, requiring additional off-street parking may work counter to that. We said one off-street parking space is advisable if you have medium to larger lot sizes and if the construction of an ADU, a detached ADU, removes an existing space. We saw some examples of that as well. And that for largest lot size, one off-street parking space could be required for ADUs 1.5 times larger than the minimum ADU size. So for those larger ADUs, which may generate more cars, perhaps one off-street parking space is advisable. And that we also discussed that off-street parking spaces should be allowed in the setback areas. If you're going to be requiring an off-street parking space, you should have the flexibility to permit it in the setback area. Any questions about those? There's a lot more detail in what I sent you. Yes.
So by we've said, what I think you're saying is, these are things that we've seen. Because you just said 3 conflicting things about parking. So I mean, we've seen this from these various ordinances, right?
We've seen we've seen them, and people's had different opinions at the end of at the meeting when we were developing recommendations. And this is part of the reason April we will be drilling down. I would argue that these are not conflicting, but please correct me if you disagree. Like, we're saying no parking requirements if it meets these conditions. If it meets these conditions, one off-street is advisable, and then off-street parking spaces should be allowed in setback areas.
Okay, so the first thing you said is, we've said that no more than one off-street parking space should be required.
Yes.
And then we've honed it down to unless and unless and unless. Is that really what we're saying?
Well, none of these say you should have more than one off-street parking space.
Right, but it could be less.
It could be less. Yes, our recommendations were never require more than one off-street.
Okay.
And then pulling back, it could be less.
Okay.
Sorry if I didn't make that clear.
Okay.
But no, this is the kind of feedback we want. Make sure there's no inconsistencies in what I wrote. At the end, I always go back and listen to the videos and I try to pull out what I hear. So doesn't mean I always get it right, or I might have misheard what somebody was saying. Any other comments?
Anybody online, any questions, comments? Everything aligned with what we've been hearing?
But again, I do encourage comments on all of the recommendations, particularly in preparation for the April meeting. Okay, so now our next section of the agenda is research and reporting. So we have a couple things we're going to talk about here. So I distributed the environmental organization survey on the 11th. What was that, Monday? I want to thank my colleague, John Coleman, who is helping monitor this online, for helping me do that. We've requested responses by the 5th of April, so we can present that feedback, the results of that survey to you all on April 16th. I will, following this meeting, send you all that that email regarding that we sent out to our environmental organizations on our list. I encourage you all to help spread that to other environmental organizations with which you work. We have a broad definition of environmental organizations, so we encourage you to take the same, have that same broad definition. So regarding the focus groups and panels, I went through all of our documents for the three we've had so far and standardized them in format. And I posted them to the webpage. So if you go to our webpage now, you'll see focus groups and panels on the left side. And the three summaries we have are included there. So the most recent one we had was that HOA and community associations panel discussion at the last meeting. So there is a summary of that on the webpage. That was also included in your agenda packet. So just some big ideas that were expressed by that panel. That ADUs can further deteriorate struggling neighborhoods, that ADUs are not necessarily affordable. There was a strong recommendation from that panel to limit ADUs to areas served by public sewer. We talked a lot about utilities, specifically in response to that panel discussion last time. We're going to be delving into it more today. There was also a lot of discussion and back and forth about only implementing ADU ordinances that you can enforce. Right, because you can have all these requirements, if they're not enforced by the local government or not possible to be enforced by the local government, do not have them. They did express that ADUs are a valuable housing product for certain populations and that they do provide housing diversity. And there was also discussion specifically when we got into the HOA questions about it being fair to charge ADU owners additional fees as they are increasing the strain on infrastructure and community services facilities. So I'll point out that that's not necessarily what you all said. That is what the panel discussion said, and that is summarized on the webpage, on the website. So we did conduct our last focus group last Wednesday on March 13th. I want to thank the members of the task force that helped connect me to housing organization individuals and my colleagues who joined me to help with that focus group. I'm going to go over the summary of that on the next slide. But I haven't typed up a full document that is comparable structure to the other ones because it just happened this Wednesday. So we did have Lisa May from the Maryland Realtors, Trudy McFall from Anne Arundel County Affordable Housing Coalition, Jessica Zuniga from the Maryland Affordable Housing Coalition, and Cheryl Meadows from the Salisbury Neighborhood Housing Services. And then after I discussed this, Adam, you're on to discuss restrictive covenants, which Adam has been researching and which we have discussed many times in this group. Any questions about this slide or the status of the focus groups before I go on to summary?
So just to clarify, so that's our last focus group now.
Yeah, we have none left.
Okay.
None left.
And the only new information that will be this survey that'll be coming in.
Right.
So that have that input to our April meeting. And the full survey or the full summaries are obviously online. So these are ones listed here are just a few that you all randomly pull out of our summary.
These ones on the left.
Yeah,
They're just the big ideas that were from that specific focus group,
right.
the one that we had.
And
last.
so because it says HOA and community associations focus groups, I'm trying to also differentiate. We had the HOA, we had the panel.
Yeah, that should say panel discussion, not focus group.
That's why I'm confused. Okay, so that was the panel discussion that we have summarized on the left. Okay, that's what was throwing me off. Okay.
I think the one voice that we've not heard from, which I think is going to be a very negative voice, is actual HOAs. I mean, there were no actual HOAs represented. And HOA management companies and HOA boards of directors really don't like anybody telling them what to do about anything. So I know that I thought that's who we were going to hear, but there was supposed to be somebody from an HOA.
They canceled the day before.
Yeah.
Well, I know we had Quinn, who spoke at least with the insight of HOAs because he works with a lot of them. So I know it wasn't quite the same. Quinn, I don't know if you wanted to share anything or if you think there's some other way to get information from HOAs. I think it's probably too late to do another focus group with them, but we were trying to, and I know Secretary Flora spoke from perspective.
Yeah, I've written HOA's documents and been pretty involved in them in the past, but Quinn, do you have any? Priscilla's concerned that we may not have gotten enough of that perspective, because might as well hear it now.
Well, I mean, the other half of that is that maybe under the restricted covenants, we're gonna hear that no matter what they think, they can or cannot, I mean, can they or can they not, have their own covenants that do or don't allow me to use, because if, I think what you said in the past, you know, different. You said.
Is it you?
It said that there are certain things where the state can put in a law that overrules the covenants in the HOAs, right?
Yeah, that's what I'm gonna be talking.
Okay,
Okay,
well,
so
I
we'll
can't
go
wait
there.
to hear that one.
So since I called on Quinn, Quinn, do you have anything to add?
Yeah, I think she raises a good point, and unfortunately, as was said, that we had a management company lined up that was going to be able to speak to give a little bit of perspective, at least from a management side, because a lot of these HOAs are not self-managed per se, so they hire these management companies that come in and kind of run the association in conjunction with a board of directors that is your homeowner elected board. So it would have been nice, I agree, to hear some perspective. I know our schedules are jam-packed. I don't know if maybe, inviting that particular person back for maybe to speak for 5 or 10 minutes, if that's an option. But I do agree, having, the homeowners who are actually going to be affected by potentially what moves out of this would have been nice to hear. And it sounds like we're going to hear some perspective on covenants. So I'll leave that to the attorney in the room.
Well, I mean, we could potentially invite, I can't remember the name, Quinn helped me connect with her to speak at the April meeting. I'll leave that up.
Yeah, we just won't have enough time.
Or offline.
Yeah, offline, maybe just reach out proactively.
I could send the list of questions. Well, she already has the list of questions. I could ask her if she would be interested in submitting comments in writing to those questions. Okay.
Yeah, let's do a follow-up, Joe, on that, just because I think it would be good to ensure that we consider, I mean, I have a pretty good sense, but I think it'd be good to proactively feel like we've had that. But, so, okay, that, and this, our clarification of this helped me understand why I was confused about that slide. So, okay, any other questions on this piece of work that's been done and that? Fine, I don't see any hands up. We're good.
Well, now I'll summarize what was discussed during the focus group last Wednesday with the housing organizations, those things I mentioned. So the questions that were asked are in red there, white font, red border. So what has the local government experience taught us about ADUs in the housing market? One comment was that ADU developers struggle with different regulations across jurisdictions. So the fact that these regulations differ depresses the market. They might become familiar with what you can do in one market or one jurisdiction, but not the other. A couple of the focus group members expressed skepticism that ADUs alone can effectively address affordability issues, and rather that they should be considered only as one among many needed strategies. And then another one mentioned that really nobody helps homeowners develop ADUs. We've talked about this before. You can design an ordinance to permit them, but if you don't provide support, guidance, incentives, resources, they're not going to be developed because we're dealing with homeowners. So that was what the local government experience taught them. How do policy or ordinance changes and market demand impact one another in the proliferation of ADUs? I thought a well-put statement by one of the members was that oftentimes local governments will, as they described it, dip their toes into the ADU world, right? They'll make some slight modifications to permit them, and then it's not enough to actually facilitate them. And then the detractors can say, see, nobody wants ADUs. I thought it was pretty well put. So I just wanted that was the description that they used. And the same person said that California's increasing liberalization of its ADU ordinances. We looked at ADUs in California a lot, and it wasn't just one bill, it was a series of bills over years, and that they increasingly liberalized them, made them easier. This finally led to their proliferation. So that's an example of them building off that first comment. If a jurisdiction wants ADUs, it must establish flexible policies and regulations that permit ADUs for a variety of reasons. So it may be for family members, it may be for renting, it may be for other reasons. So if you really want ADUs, you need a policy that will have that flexibility. And a couple mentioned that ADUs are comparable or can work alongside missing middle housing products. I know missing middle has come up a couple times in this task force. It's not the focus of the task force, but they saw it as a comparable strategy or supportive strategy. What practical issues associated with the development of ADUs must the task force address? There was a lot of discussion last week about owner occupancy requirements. And a couple of the focus group members said that they may be necessary to both pass ADU legislation and limit impact on neighborhoods. So that was a regularly repeated comment. We delved deeply into actually enforcing owner occupancy requirements over the long term. How is that done? And they talked about, or they suggested that rental licensing requirements, if those themselves are enforced and maintained, can maintain this owner occupancy, because you have a rental licensing on one of the units and not on the other, you make sure that's maintained. You can know over the long term that there's an owner in the one home. So you have to obviously enforce that rental licensing program. The focus group members were generally opposed to familial relationship requirements that we've seen in some ordinances. Another strong statement was when we talked about parking, if the issue is parking, then address parking.
Not me. I did not, when I read that, I didn't understand it.
Well, they're saying if you have an issue with parking in your community, then figure out a way for parking not to be an issue. Don't restrict ADUs because you have a parking
You
issue.
already have it.
Like they were making the statement that like, you're just using parking as a reason to say no to ADUs. Deal with the parking. Don't restrict ADUs because you think you have a parking issue. I'm sure you want to comment.
Yes, I do. There's in certain neighborhoods, there is the parking is an issue and it's not gonna go away. There's no way to legislate, address limited parking, especially if you live on a major corridor. And I'm speaking about US 1, Mount Rainier, Brentwood, North Brentwood, City of Hyattsville. We have a parking issue? Yes, we do. How do we address it? We don't. We're just limited on the towns. There's no way around it. There's just simply no way around it. We do utilize residential parking, so you have to be a resident to park on certain streets. We do have that, but it's virtually impossible to address. And in the Chevy Chase area, the way that they legislated it, I'm sorry to say, if you have an ADU, you've got to be able to provide not one, but 2 off-street parking facilities. And what it does is it addresses the quality of life of the people that already live there. Right? So we're concerned about ADUs and affordable housing, but I can't jeopardize the 80-year-old lady who's been living there for 40 years because we want to address affordable housing. I just can't have that. I can't have her walking 4 blocks from her car to park because the person has 4 or 5 cars.
And the other side of that is if you have a limited number of parking spaces, street parking or whatever, and you have one family that has 2 adults with cars and 2 kids or 3 kids with cars. So now you have 5 cars. And then you have somebody who has a house with one driveway, it's 1 person, they build an ADU, now that's 2. So they only are talking about 2, but they only have space for 1 off-street parking. Versus this family with 5 cars, but they don't have a restriction because they all live in the same house. As opposed to in an ADU within that house or behind that house, so there's an equity issue.
Well, no, and so how the town of Brentwood addresses that each house is limited to 2 residential parking and 1 visitor. So in your scenario.
So then that's consistent and it's fair to everybody.
In your.
It's whether or not you have an ADU or no ADU.
Correct.
Everybody gets 2 spaces.
2.
I don't have a problem with that.
There you go. Yeah, and that's how we address that situation.
It has to be fair and equitable across.
And it is, you have to, yeah, and you have to pay for it annually and you have to renew. and you have to renew, and the
That's
block.
that's for on-street parking.
Correct.
Off-site parking.
Yeah, off-site, for driveways, we don't dictate,
Right.
but for street parking,
That's what you have to.
you have to have each car has to have a permit and you get one visitor. I will tell you that a lot of, the reason for that is because of the streets are you can only park on one side. So we're very narrow streets. And so that it just becomes real convoluted, so.
That's all I care about is fair and equitable.
Oh, no, the only thing is that not all of our streets have 70 to 80% of the residents must agree to have residential parking for their unit block. They must submit a petition, go to town council, take 60 days, things of that nature. So, I mean, it's an arduous process, but we have 42 streets in the town of Brentwood. I'd say maybe 15, 20 of them have residential parking on the block. Well, I mean, about 18 blocks that have residential parking.
Thanks, James.
And in general, how wide are your lots, which tells you how many cars you can park on the street? What's a typical lot width?
Most of the inner towns are like half an acre, if that, quarter of an acre. They're relatively small. The larger ones, and I have to be honest with you, the larger ones were generally the huge property owner from back in the day. And he sold part of the farm and then he broke it up. So when you see a large home in one of the smaller neighborhoods, it's because that was probably the landowner's home. And what he did is when he sold the farm or the family, whatever, they started breaking up the properties. And that's how that happened. And in certain situations, there weren't much restriction, so they could break it up before different ways. And we try to frown on it, but there's not much we can really do about it.
Thank you for that perspective. I think what I'm taking away from it is that the cautionary note there is that if there is permit parking, you do have that potential for that residential property have 2 spaces, and the owner in the house may not have a car at all as long as it's associated with the property. Because then adding the burden on the ADU is really more about the requirement of that property. And there might be a way to sort of really think about that, I think, in the regs, that it really is property, because you may not have a driver, and then of course, transit is always a good thing, so.
And let me, one last thing, with your scenario, trash is another issue, right? So each home only gets a certain amount of trash bins. If I go the ADU route, I then have to deal with that as well. Person who's 88 years old is not going to produce the same amount of trash that a family of 5 is going to produce.
Right.
However, the 88-year-old senior is still being charged the same amount of whatever the rate is that we do for trash, that the home with 5 people in it is being, and that's not fair.
As long as it all fits in the bin.
Correct,
You're
but
good.
it doesn't, and so a lot of our larger families have 2 and 3 bins.
Interesting.
So if the 88-year-old then brings in an ADU
Mhm.
for his house.
Correct,
They're still only gonna have 2 people's worth of trash now instead of,
correct, but you're only designated 1 bin.
yeah, but they share the bin, right?
Oh, that's correct,
Right.
yeah, that's
Right,
correct.
So that's how you
That is how.
basically
But
equalize.
the flip side of that is I can't dictate who's living in the ADU. The amount of people who are living in the
But
ADU.
as long as they can keep all their trash in one bin,
That is
good to go. And they only get 2 parking permits and a gas.
And into the trash folks that pick up our trash, it's 7 a.m. I don't care if it's 1 bin, 2, 3 bins, I'm picking them all up and I'm done.
Right.
So I mean, that's the
Well, it's
reality.
interesting. I mean, I think we were all learning so much about all the little details here, aren't we? So, okay, well, Joe, let's finish up this piece.
Sure. So I want to point out, like, a lot of these responses to these questions deal with topics we've already addressed. So I share them with you all, not because what they say is going to make me go back and change the recommendations that we've already established, but just so you all know, especially when we get into prioritization in April, you have this information, you have this input that can contribute to your own decision-making on this. So the next one was when we're talking about practical issues.
And these were just what we heard.
Yeah, these are just what we heard from
Agree
them.
or not agree?
Exactly.
This is what we heard.
Same thing with the
I don't
HOA.
agree with short-term rentals ruining a neighborhood. I think they can also help someone stay in their home because that gives them income to stay in their home. So there's a lot of things we all may agree or disagree on, but this is what we heard.
Yep.
And there's a more detailed report on it.
Not yet, not for this one.
Oh.
This one I haven't, we only did it last Wednesday. Yeah, there will be. I mean, this has a lot of the stuff that it's going to have on it. This is the focus group we just did last Wednesday, yeah.
So we'll have plenty of time.
So regarding practical issues, at least one, maybe a couple, I can't remember, 'cause I have to go back and look at my notes, but so that minimum lot size requirements, maybe they recommended them as potential solution for ADUs and height limitations because they can help maintain their neighborhood character and preserve privacy. One of them made the comment that neighbors may be reasonably concerned about a two-story ADU next to them when previously there was only a yard as an invasion of their.
Can I just ask quick, you're talking about detached here, right?
They didn't say that, but you would imagine that that's probably what we're talking about, yeah. And then there was the statement that short-term rentals and ADUs can ruin neighborhoods. That was somebody who said they were very disappointed that short-term rentals were allowed in an ordinance, and they thought that they could ruin it. All right, we have one more slide. Responses from this group, all right. How can ADU policies, regulations, and programs be designed to ensure that ADUs serve as an affordable housing options? I think all of them agreed that income restrictions based on AMI or otherwise cannot be managed and they won't work for ADUs. But they said even in expensive neighborhoods, smaller ADUs can yield more moderately priced units and that ADUs are one incremental option to help with housing supply and affordability. And that ADUs increase housing diversity and slow long-term rental cost appreciation. The next question is, what are the chief arguments or stipulations for convincing community members to support ADU ordinances and development? Next one I put in there, it's a little colloquial, but it was the first thing that was said is your grandson doesn't have to live in your basement. And essentially what that means, I mean, we know what that means, but it's that, you know, if you make it personal, you make ADUs personal and you discuss, you know, how they can benefit individuals, not just as a zoning ordinance strategy that you may be able to convince people of supporting them. Again, they came back to this owner occupancy, that owner occupancy requirements make ADUs palatable and that they are an acceptable compromise. So that was the opinion of a couple people in the focus group. They also, one of them strongly said, Maryland's don't need convincing. This is that the polls show, surveys show that once people are made aware of what ADUs are and what they can do, that there is general acceptance and that what we need is awareness more so than trying to convince people of ADUs. And then the last question is how can the state and local governments partner with housing organizations to develop ADU policies and regulations and support their construction? Government financing to support ADUs at all levels. There was a discussion about the lead paint inspection requirements, and I'm not an expert on this, but it was comparable in many ways to what we discussed before with sprinkler requirements. One person said that there's redundant and too frequent lead paint inspection requirements. Currently, every tenant turnover requires strict compliance, which is a burden, and they said it seems like overkill and that inspections are expensive. Being able to use rehab loan funds for ADU construction, this could be either community development corporation or housing organizations, rehab loan funds, or rehab loan funds at the state or local level. Use the real estate data to inform decisions. We did get the survey from that supports that one Maryland poll survey shows support for ADUs. We did get that, and FAMI is looking at that as part of her work. But really using the data that's out there to inform local and state government decisions, and then working together to provide technical assistance to homeowners and others. So, going back to one of the very first responses and the very first question was that there's just no support for homeowners and therefore ADUs are not going to be developed. Yes.
I wanted to come back to that one bullet point because I know we've talked about it before of the Marylanders. Show they support ADUs and what we need is awareness. And I think that really speaks to our final document and recommendation of a very, very strong definition of exactly what an ADU is and what it isn't will go a long way for any of our future recommendations when we pull that document. our April session. I almost kind of doing a few things at once here when we talk about our April session. I almost think that becomes one of our brainstorming group activities, making sure we all concur exactly what we're talking about as an EDU.
Absolutely. We do have the definition in the glossary,
Right.
that's a definition pulled directly from SB 382. It does not, we don't have an anti-definition there, but we could definitely consider that, absolutely.
Yeah.
I would argue we need to make sure we include the definition as in SB 382 in our discussions, because that's what the bill assigned to us, but we can expand upon it.
No, I think we should feel full freedom to define ADUs based on our research and information. The bill is the bill we were tasked with, but that doesn't mean the report can't take everything we've learned, as goodness knows the bill written, they wouldn't have had the value of all of this information to feel free to maybe define it for the purposes of the report, you know.
So any other feedback, thoughts, response to the housing organizations focus group? Then their own responses to the questions.
One thing I'm curious about personally is the financing piece. I'm gonna turn to Theo. Are you aware of anything that's out there?
Yeah, unfortunately, no. No, there isn't anything out there. Is what I'm gonna say. Yeah, everything that we offer is either targeted towards owner occupied housing or low income rental. The only possible kind of potential area would be if there's a low income renter and an ADU that needs energy efficiency upgrades, potentially. But that's not to construct an ADU or anything along those lines.
And that's DHCD.
Yes.
But what about any kind of, if you were doing banks, it'd just be private home equity borrowers?
Oh, yeah.
But there's no, I have both in terms of there's nothing out there that's special to sort of help
Not that I'm aware of.
support, because we've learned these are, they're expensive.
Yeah.
Let me interject. Pepco does offer some incentives for energy efficiency as you do new construction and or renovation. So and I guess it's Pepco for us to live in the DMV. It's Pepco and Exelon Corporation. They have another group, and I forget what the name of it is, but they deal specific, that's all they do. You're building, you're renovating, how can we come in, provide you with alternatives for energy, whether it be lighting, you name it. That's not my area, but they do offer that inner incentives to help you with your construction costs. So they'll come to you, evaluate your situation and say, okay, you can do A, B, C, and D. I will admit that it's applied to our new town center that we're building, but they do venture out. There's a residential side and there's a commercial / government. So there is Pepco, and I'm sure Washington Gas is the same thing.
Yeah, I mean, I would think, as we think about the resources page or sort of aspects of this is identifying either any models around the country or anything in here that would, so especially if I'm thinking probably as non-chair here, but if any objective of ADUs is to create more, let's call it middle housing opportunities, that's not going to happen with the current cost of doing these things. And so that could be part of some of our recommendations, that there needs to be something to make these financially viable, or in fact, they will just be Airbnbs. Because if they're financially viable, then you could build it and support some of the population we want to try to target in that middle or, grandson market. So I'm just curious about that, so this.
It's maybe too technical, but I think for DHCD, one of our challenges is when we create new programs, usually we have to have some type of regulatory authority or some type of mandate from the legislature. So I'm not sure if we have the authority to just create an ADU financing product, even if we use special funds or something similar. I think that would have to be part of the recommendation, some type of authority.
Oh, you talk to the banks.
Oh, yeah.
CRA,
Oh, yeah.
yeah.
Externally, yeah, no problem, but
Sure.
for DHCD specifically.
Okay, cool. Any other questions? Anybody online, or we've got, just want to make sure we've got, is it Amy? Hand up? Amy?
Yeah, thank you. So I think that the focus group comments are very helpful. I think there are a lot of ideas that we really need to move forward and support, like the owner occupied requirements, making sure that this is a by right use. But I would just caution the the easy and low hanging fruit argument that all of the zoning regulations may be at fault, and just looking at and listening to the conversation about parking, about height, about lot size. I just want to bring us back to this frame of reference that to be equitable, our zoning codes have to be consistent. So when we start looking at this use, which we want to support, but doing so in a way where we are personalizing some of the characteristics of who is being served or what needs there may or may not be, we can't zone based on personal circumstance, but what we can do is be consistent not only within this accessory residential use, but we have to be consistent with all uses in our zoning codes. And so just to keep that thought in mind as we're mulling over this focus group's comments and all of the focus group comments that we are contemplating, and then going to draft policy statements as a planner in a community that's very diverse, that is very rural with development on septics and development in a more urban setting, though not with mass transit. All of the many layers of requirements that we've been discussing on these last several slides are not only relative to this land use, but the existing land uses and surrounding land uses. And there are impacts that and unintended consequences that we just have to keep in mind so that we're equitable within this decision-making process and with our existing zoning.
Thank you, Amy. Good reminder. Appreciate that. Priscilla, I think you had your hand up, and then we'll probably.
Well, I'm just gonna say I found these very helpful, all these comments, because I think this group all really they're on the same page as we are about the definition of an ADU, and that gets back to definition. Because I think that the panel last month didn't necessarily look at ADUs the same way we've been sort of talking about them. So, converting a house into 4 apartments is different than what we're talking about. So these comments I found very useful.
Okay, great. Thank you.
In fact, I think
Yes,
I'd like
yes.
to make just a couple of comments. I think this is great, but I just want to get out the one thing I fully disagree with in the focus group was not to have ADUs without public water and sewer. Just 2/3 of Baltimore County, for instance, is without, maybe more, is without public water and sewer. There's plenty of large lots with big houses on them, and I see no reason, assuming the septic works, that you can't have ADUs there. The thing, I've mentioned this at prior meetings, but there's one thing that's bothering me, and that's covenants. I understand we're going to talk to that in a minute. The other thing that's now beginning to bother me is I think we're going to work through all these zoning things. This is kind of a zoning group, but how we finance, I'm just beginning to think about how ADUs, which can cost as much as $100,000 easily, get financed, not so much at HCD, but in the private mortgage market. Is that a second loan? Is that a line of credit? What does your primary lender think about that? And if we have time today, Rebecca, I'd like to explore that a little bit further.
Thanks. Well, try to do that. Thank you. Okay, are we on to covenants?
Adam's on.
Adam's up. Thanks for being here, Adam.
No problem.
So you want to introduce yourself to the
Yeah.
group, and then, this hot topic that's been just coming up repeatedly.
Our camera.
So I'm Adam Snyder. I'm in the Maryland Attorney General's office, and I'm kind of counsel to the task force. And I'm also counsel to the Department of Planning, which is why I'm counsel to the task. I'm going to be talking about covenants, conditions, and restrictions. You'll see me or hear me say CCRs sometimes, just because I'll fall into that acronym. These are restrictions in deeds or in homeowners bylaws or rules that might restrict how property owners can develop their land and might actually restrict whether they can put ADUs on their property. So the question being presented here is, can those CCRs be overridden by legislative enactment? Now, so when you look at this, it's a constitutional analysis. You start by looking at federal law, and these types of CCR overrides are challenged on two grounds: on federal takings law and contract clause law. Takings law is probably familiar to most of you. It's the one that says the government can't take your property without just compensation. It's likely not a significant obstacle to legislation that would override CCRs. And that's because takings plaintiffs typically don't win unless the governmental enactment deprives them of all economically viable use of their property. Unless you're in that box, a takings claim is a real uphill battle. And it would be evaluated by a three-pronged ad hoc balancing approach, by which the courts evaluate the economic impact of the governmental restriction, the character of the governmental action, and the extent to which the governmental action interferes with reasonable investment-backed expectations of the property owner. And in this scenario, when we're talking about CCR overrides, the economic impact is not going to be great. It's going to be, you know, if your neighbor is allowed to build an ADU on their property, it might affect your property. Maybe you lose 10% of its value, maybe 15%. But in order to prevail under that prong, you have to be like an 85%, 90% deprivation of value. So this isn't anywhere close. It's not going to weigh in favor of a taking. The character of the government action also doesn't weigh in favor of a taking here, because the government is not coming in and telling anyone that they can't develop their property. It's doing the opposite. It's telling people that they can develop their property. And CCRs, by definition, affect how your neighbor develops. It doesn't affect how you develop your land if you're the one trying to enforce it and bringing this type of takings challenge. So that too doesn't weigh in favor of the takings. That leaves whether it interferes with reasonable investment-backed expectations, and arguably it does. You know, some people would say, hey, I bought into this neighborhood because of these covenants and restrictions, safe in the knowledge that no one's going to build an ADU next to me. But whether it's reasonable to buy into that circumstance and feel as if the rules that govern land use are never going to change is questionable. The people who have looked at this issue, and there are law review articles written on this very issue that have come out in the last few years, say that you know, that's the best argument people are going to have, but it's not going to be enough to carry the day in a takings claim. So it's extremely unlikely that the takings clause is going to be an obstacle here. The contract clause is one of these constitutional provisions, when you read the words on the page, seems like a real robust protection for contract rights. It says essentially that the government can't substantially impair any contract. But the way that contract or that constitutional provision has been applied is, again, a balancing test where the courts look at whether you're impairing a contract right, and arguably that would be the case here in terms of you'd be impairing this right to enforce a restriction against your neighbor, but you balance that against whether the government has a significant public interest behind its action. And here, where we're talking about a legislative enactment that would be designed to get at a pressing housing crisis, I think that that balance will easily be weighed in the government's favor. Particularly so if it were established that these anti-ADU CCRs, they've got two acronyms next to each other, have some historical connection to the overtly racial restrictions that were invalidated in the 1970s. And that's what the tack that California has taken in justifying its ADU CCR overrides is by saying that these are effectively measures that homeowners and land developers put in place after overtly racial restrictions were ruled unconstitutional as a way to try to accomplish the same goals, not ADUs specifically, but ADUs along with other types of restrictions that keep force landowners into only having a large single-family house on their lot. Whether that case can be made in Maryland, you know, we heard from a speaker earlier.
Litigated in California, was that question?
That hasn't been litigated yet. It was like, I think it was enacted last year, and there's no cases yet that I've seen. But the contract cause of action almost never prevails. It's not a dead letter, but it wouldn't be a serious obstacle here. To me, the better argument, if you were a plaintiff bringing one of these cases, would be under Maryland law, because Maryland provides a little bit greater protection to vested contractual rights and property interests. Now, I still think that a CCR override would be upheld under Maryland law. There are no cases on point though. So we're kind of looking at different data points and trying to draw conclusions from them.
But could I just jump in for 1 second? I sent Joe the case of Dunbarton Community Association, the Drew Ridge Cemetery, which was Chief Judge Bell's last opinion when he was on the court, which basically, this was a cemetery that said when you bought it, had a covenant that when you bought a cemetery plot, you had to use it for a cemetery plot. They wanted to sell the unused, and the covenant went on in 1898. The case was litigated in 2015 or something like that. And what's now the Maryland Supreme Court held that the covenant was primary and couldn't build houses on it, had to be a cemetery plot. So have you looked at that at all or considered that?
Covenants, CCRs are fully enforceable between the people who enter into them in the absence of state legislation overriding them. They are contractual agreements, as you pointed out, courts will enforce them. But the question, I don't believe this was an issue in Dunbarton, is what happens if there's a state statute that comes in?
It was not an issue.
Yeah, and that's where where this issue is joined. And you think about it this way, and this is drawing from federal contract laws jurisprudence, but I think it bears to some extent under Maryland law as well, is that you can't, through private contracts, limit a state's police power. The state regulates in the public good as an exercise of its sovereignty, and private individuals can't contract to lock in a set of circumstances that would then be immune from governmental action. You can't restrict the government's sovereign police powers in that manner. Now, if it's abrogating a vested right, well, then it may run afoul of Maryland law. But Maryland courts in this area have spoken, again, not in a CCR override context, but have said that covenants and restrictions are valid unless they conflict with public policies set forth in a Maryland statute or violate the Constitution. So if we have a statutory enactment that says that CCR shall not be interpreted to prevent the construction of an ADU, and it's linked to as a measure to get at this, difficult housing crisis, that's probably going to be enough as an important public policy that the courts would say, yeah, your CCR has to defer to that.
Works for me.
Now, when you get into more of a more trouble under these provisions of Maryland law when you're like, if you have an accrued cause of action. So like if your neighbor has built an ADU before the override is in place and you're in court with them, it may be that that law that gets enacted in the midst of that court proceeding doesn't get applied in your court proceeding because you already have an accrued right under this CCR and are seeking to enforce that right. But beyond that narrow circumstance, I think that Maryland courts would uphold the constitutionality of a CCR override under Maryland law. And I can tell you, our office would sign off on any such legislation as being constitutionally permissible and defended in court of Virginia.
What you're saying, if I understand it correctly, is it's defensible if there's a nexus to an important public policy like a housing crisis. I think that's very good analysis.
Yeah, and particularly so the if it's an outgrowth of these overtly racial covenants and restrictions.
Can we really make that case?
See, I remember
that ADUs have something to do with, discrimination. That's a stretch.
I know one of the speakers a few meetings ago touched upon that, and I've heard that also in other contexts, not ADU specifically, but measures that prevent you from expanding the use of your lot in something other than a traditional single-family dwelling.
Are there any cases on that you can think of? You don't have to say the second.
Not Maryland, that make this distinction or that make this connection.
That's saying the zoning need for a single, family lot is invalid because it's basically racially discriminatory.
No, these are legislative findings that California made to support its override, which again hasn't been tested in court.
But are there any examples, not necessarily housing, but anything where the challenge would be that you can't tell a HOA what to do, but there's legislation that conflicts with their bylaws, and they've been able to impose them?
In other states, yes.
But not in
Maryland. But there have been.
Because you made a comment, I thought about composting or something.
Well, I was going to get to that, in Maryland law, there actually are already on the books several CCR overrides.
Okay,
One for backyard composting, one's for solar panels, one's for residential childcare centers. Some of those are prospective only by their terms, the one for residential childcare centers, which means that it wouldn't apply to CCRs that were in place before the law was enacted, which is a much easier, legal pathway. There's really can't be any challenges to that. But the other two are not restricted that way. They have.
So like composting, you can have all the bylaws you want for composting, but by law, they're allowed, period.
Right. Yeah. And there's actually one that's going through the legislature right now. It is House Bill 783, Senate Bill 773, which would override any CCR that would restrict or prohibit rentals of 6 months or more. So long-term rentals is what it's trying to get at. And then there's no limit. Again, that too, I think, is this trying to allow people ways to use their property to generate more money because
Have any of those overrides that you just mentioned been litigated, tested in court?
This one just now, or the compost and
the composting?
no.
Okay.
Now, the one, I went back and looked at the legislative history on the one about the child care centers. And as initially drafted, it was prospective, or it was didn't have a time limitation, which would have applied to existing and future CCR. Then the Guilford Association from Baltimore City wrote an impassioned letter saying, wait a minute, we have.
Not in our community.
We have these contractual, right to determine how we want our neighborhood to be. And the court or the legislature put on this prospective only provision in order to avoid that potential challenge. They didn't have to do that, and we would have seen, if they hadn't done it, the challenge had been brought, we would have seen how that got played out. But it is something that does resonate with some legislators, and so it might be a difficult ask for the legislature to go ahead and make it retroactive, but if they wanted to, I think it would be constitutional. Joe asked me also to talk a little bit about local government powers in my aspect, and I'll just say very briefly, charter, it depends on their, so the question here is what happens if the state doesn't do it? Can local governments do this? And I think charter and code home rule counties would be pretty much in the same shoes as the state here, would be able to do it. They have comprehensive police powers under the Express Powers Act, so I think they'd be able to do it. Commissioner counties, it's a closer call. They don't have broad constitutional police powers, but they do have statutorily delegated powers with respect to zoning and planning that can be exercised, even if it might displace or limit economic competition by owners and users of property. Those things together makes me think that, yeah, I think commissioner counties could probably do this also, but generally speaking, they have fewer powers than charter counties. So I think it's a little bit a closer call there. But if the state were to authorize counties to do these types of CCR overrides, that would take care of the issue. Wouldn't be a mandate, it wouldn't require them to do it, but authorizing them would remove that question as to whether local governments have the power to do this. So any questions? You can ask questions, but just a kind of a caveat, lawyers, can never guarantee anything.
Directly.
Yeah, there may well be challenges in this. If there's a retroactive CCR in place, like I said earlier, our office would conclude that it was constitutional and would defend them, but there's no accounting for taste in the judiciary. My money's on that they be upheld.
Great, thank you.
Well, that's, as far as I'm concerned, that's the right answer.
Me too.
You're a very good lawyer.
Are there any questions out there online or any clarifications? Everybody's good? Yeah, this brought me back to my taking case law when I was in high school.
Sounds like we have somebody.
I think that's a great answer. It
Did someone raise
resolves.
their hand? Is that Quinn? Quinn?
Yeah,
Is it-
but just one thing. Great job, Counselor. I just wanted to add another area where Maryland legislature has stepped in is with respect to electronic or electric vehicle charging stations. So that's a relatively new one as well. So essentially the Maryland HOA Act and the Condo Act does say that any recorded covenant or restriction that unreasonably prohibits EV charging stations is essentially prohibited. So just to add another example of where the legislature has stepped in.
That's great. Thanks, Quinn.
Well, that resolves, Mike. I was very concerned about the effectiveness of covenants. I was the expert witness in the Dunbarton.
You know it well then.
One all the way up and then overruled by what's now the Supreme Court. My concern is now resolved. It may get litigated in the future, but so may anything else.
Great, thank you. Thanks for
Sorry.
doing that. Yeah, Theo, one question?
Just, I want to make sure I'm understanding. So you're saying legislative intent is very important. Is that correct?
Yes, particularly if the legislature wants to draw, kind of this racial component. But even if they don't want to go that direction and just justify it on grounds of trying to get at this housing crisis, that would be important to bring out of legislative history, but I would assume that would come
Okay, so it doesn't, a whereas clause, if you will, doesn't necessarily strengthen the legislation, may see the rule.
Yeah, it would help document what the legislative intent is. I would assume that would come out in the the committee hearings, the written testimony. I think it would be all over that. Any of them that would be all about that.
Thank you. Okay, I think we're gonna get this last piece of this segment done, and then we'll take a quick break after before we go into utilities. So.
So update on reporting. I transmitted the final report outline after a couple of iterations of it and internal discussions to you all last week. Happy to receive your feedback on it. It includes, and here's just a screenshot of it, priority recommendations. It'll describe our process. It's going to organize best practices by topic, similar to how we've structured our meetings, and then some appendices that are listed. The appendices would be cooperative terms, some of the updated. Thank you to my colleague, David Dahlstrom. Everybody else is welcome to contribute to it if they'd like, or provide extra comments on it. It'll include the two inventories we've been working through, the Maryland ordinance inventory and inventory of other state legislation, and the housing market analysis, which we'll learn more about next, or in April, that Fahmy met last time is working on. So obviously what we do at the April meeting is going to have a big impact on the priority recommendation section right there. And I know Secretary Flora, we've been and the rest of us have been discussing it, at least internally, about the priority recommendations being organized, or at least a portion of them being organized in the form of a table that is context sensitive or describes different kinds of communities. If you look at the recommendations throughout, it provides the ones that we've developed. It has that context sensitivity. That could be to lot sizes, it could be to proximity to other uses or transit, rural, suburban, the like. So we're going to be, I haven't developed it yet, but for the April meeting, we'll be trying to fill in a table like that, or at least providing the content to help fill in a table like that. I don't know I know you only got it last week, so you probably haven't had much time, but if anybody has any feedback on the final report outline or just general thoughts about the final report, something you want to make sure we include, yes.
Back to my same statement from before of the definition of ADU, really having that right up, maybe even after the executive summary, of having that just be, it's a level set for everything that comes after that, and then going into the priority recommendations and after.
Yeah, Jennifer, I think that's important. I think when we do the final design layout, we can also even just do it as a insert box or something where it really pops.
This one might be a silly question, and maybe I missed this, but is the final report simply a white paper on ADUs, or is it recommendations to do something specific to the legislature?
It's recommendations, policy, and other recommendations. I don't have the language in front of me.
Oh, really?
To the general assembly governor.
It's a recommendation to the, okay.
I would say that's why I know I personally feel that. Unfortunately, in this day and age, people don't always read a lot, and so the meat of what we're gonna really want to get out there is gonna be in that executive summary and those priority recommendations, and then the white paper, so to speak,
Right.
becomes all the backup.
That's what I was hoping.
And that's kind of how we're envisioning it right now, because we know that we are not, and for anybody out there in the public that may be listening, we are not, we are not a legislative or an approval body. We are simply taking all of this information and trying to come forth with this set of priority recommendations that we will do our best, if not to reach consensus, reach consent. I view as very different. Around sort of what those are, and try to organize in a way, as Joe indicated, where we are respectful of the fact that there is not a one size fits all. But it doesn't have to be the Wild West either, so to speak. There's got to be a way to try to create some way of viewing these, and that's going to come into the art of finalizing how we really kind of present this, but we really want to have some of that, I think, and obviously that's another part of today, but framed as best as possible so we can be as constructive as possible in that. So these things framed up. With all the input too.
I have an off the wall question. So the delegate who sponsored this whole initiative to begin with is not part of this task force.
Senator Washington was one of the co-sponsors.
Yeah, but the delegate was not.
He was not a co-sponsor.
No, Tom Stewart was not.
No,
No. So do we know who is gonna take this and run? Is it gonna be Senator Washington and Delegate Stewart who are going to?
it won't be Delegate Stewart necessarily. Who were the other co-sponsors of the bill? Does anyone remember? Was it just Senator Washington?
It's the only name I recall, but I'd have to.
Yeah.
look.
So this will be a report back to the General Trump. I mean, it's not just to her. It's a co-sponsor, it goes back.
So we have no idea who's going to own it.
If you do a good report, various legislators are want to hop on board.
I am sure as much as I've seen you in Annapolis this particular session. I think the idea, the other reason for the June deadline is keep in mind, I know certainly with our agency and all the agencies, we're already looking at next session. So for the report to go in whatever direction or to have a sponsor, it's imperative that we obviously require to also, but the June deadline is critical. And then it's gonna be getting it out there, it's a report for the legislature, but it'll be getting it out there also to determine, not for us to decide, but others to decide. Is this saying anything that anybody would be interested in sponsoring, in which case then you start that process already towards next year. So, but we'll talk about that more and we'll maybe map that out so folks can be more aware of what happens next. I can assure you, under all circumstances, your good work, everything that has occurred here, will certainly, as we've done all along, be publicly available. So MDP will certainly continue to have all of this available and be pushing it out as a awareness raising, if nothing else.
So should we encourage certain senators or delegates?
I'm not going there just yet. I think I'm gonna move us along and
Well, I think that's a little premature.
yeah, we don't really, I think,
We don't have a report yet. When are we asking?
No, I mean.
yeah.
Yeah, sure.
I think for this, please do take a look at the report outline because that is going to be framing for our April meeting. And so we've been trying to do this as we go so that you can sort of have the end in mind. And we know that what comes out of April, some of it's factual, and we're already compiling, and that'll be a little, use the word easy, I know staff's working hard on this, but that'll be where we're headed, right? So, but I wanna move us along in our time. So Joe, I think with one more slide. Yes, this was really great. Actually, I really enjoyed seeing this way.
Yeah, so during the last meeting, this came up, was presented by a few task force members about how there was a blending or confusion of guiding regulatory documents and a lot of the recommendations we were making and the topics we were discussing. And I know I'm going to turn it over to them, and also Susan also contributed. We kind of had parallel efforts going at the staff level and the task force level. But what I'm showing right here is what Deborah and Mandy put together. So I'm going to yield to either one of them to share their work and their thoughts, and then I'll also let Susan chime in.
Who wants to talk about Andy?
Deborah.
Oh, we can let Deborah go first. Deborah?
Oh, okay. Hi, I'm sorry to not be there in person to talk about this today, but yeah, Mandy and I had been meeting in between since our last meeting and just kind of discussing the code implications of everything that we've been talking about, and did sort of a deep dive and thought we need to make this much more clear. So much like it's been said a few times, we need to know what the definition of an ADU actually is, and we need to be adhering to that definition. I think we both were really feeling that way too. We also need to know the definition of exactly what it is we're making recommendations on, which portions of things that are impacted by ADU development are really under the lens of the things that we're talking about. I went through all of the comments to date to see what people were commenting on. and used that as kind of a basis to understand where, you know, where these things also all sort of fall. So everything you see here is stuff that has been discussed in the meetings to date or through the comment portals. It's not, you know, it's probably not a totally comprehensive list. There's probably other things, and some of them are debatable on if they fall under zoning versus other, but we thought it was a good starting point.
Yeah.
Mandy, you have anything you want to add to that?
Yes, I mean, some of them overlap, but we really thought it would be important to have a visual about where these different buckets fall under and all the different categories, you know, as we're drafting recommendations, who they're affecting.
Susan?
And I guess,
Go ahead.
sorry, I'll just say one more thing. I think the thing that really was important to us to discern is that the things that fall under building code are not really, in our opinion, not really up for sort of debate or recommendations on whether or not they apply. I think that is a regulation that applies to a building and is not, it's a life safety regulation for the most part. It's a health, safety, and welfare regulation for the most part, and it doesn't really seem to be something we should be addressing. So I guess addressing it maybe by saying, you know, we defer to building code on it. And, you know, I think we'd also welcome anyone's reaction to that, but talking about fire suppression and sprinklering and things, that's a building code life safety issue that I'm not sure really belongs part of the overall recommendations.
This is fabulous. Thank you. Thank you for your work on this, because I when I was reviewing the materials today, I looked at this and I was just like, wow, this is great. Really just kind of sorts, you know, it's a sorting process, and what I can tell, very, very accurate and incredible tool. And, you know, the link, as with all of our presentation, and you kind of see the purplish letters, those are all hot links to, you know, the table behind this and whatnot, but really appreciate the work that was done here, and it's extremely helpful, and it'd be really helpful for the public and others to really have that sorted, I think, and really, I think does get through a lot of what the confusion is sometimes. I want to just call in Susan and then see if there's any questions on this. It's obviously a really nice tool, but Susan,
Sure.
yeah.
Sure. We put together, it was in the backup attached to this document, and surprisingly, we were very close in our thinking. So I was really pleased about that, and I really want to thank the two task force members that worked on it, because it was a pretty big job to go through everything. So yeah, I think there's room for a little more discussion about you know, certain aspects of it. Do we want to include all of these topics? That's something we need to ask ourselves, because it gets long. It's going to be very, very long, but I had used the recommendations, the draft recommendations to go through. And so very similar approach. Yeah, so great job. Thank you so much for your work and your time.
Well, I think that this is great. I think there was a question just a few minutes ago as to whether we can do anything about the building code or the life safety code. And I think the answer, I could entirely concur. You can't do anything about it, nor should you do anything about it. But I do think this is all very helpful and ought to be included somewhere in the report. The one thing out of all this that gives me the most pause is character of the lot. As soon as you say character, it is the most subjective thing. And I think we talk about being ministerial for ADUs wherever we can. I think that's always a problem, especially if there's a public hearing.
Yeah, and I think that's why it's under these review boards. I mean, these are sort of very customized, and they are subjective. Sometimes we've all sat in front and been on either side of those tables.
We've all been there.
And so this is great. I am gonna propose we take a 5-minute break. So folks have questions, and then we will absolutely find a way to integrate this into the report as a way of continuing to help with this process of people understanding where we're focused. And I would say for the most part, we are focused on the zoning column. We may
Sure.
have thoughts or information, regarding the other columns, but we are primarily focused on the zoning column. So I think the group that's already got their head into this, if you see any nuances, or if others have thoughts or ideas, obviously, lead them probably still through Joe, because we want to kind of keep that funnel going, but get this, sure that we get this.
I would just say the critical area is largely a zoning problem because it restricts one house for every 20 acres, one house for every 50 acres. But I completely agree with you on the rest.
So there's a lot of nuance, but yeah. Great, let's take a 5-minute break and then we're gonna come back and dive into utilities, yay. Utilities, boy, we've been saving this best one for the last, right?
So
I think it's an exciting topic. Everybody ready? Okay.
So this is the last topic as described in the research plan that I presented in October or November. Other topics have come up, as I mentioned, but this is the last one that we're looking closely at Maryland examples and other state legislative examples. So as usual, we'll look at some resources and examples more generally. So the California ADU handbook, we've looked at this one before, but it's got a lot of good information. It allows, it describes, when it's describing its legislation, it allows jurisdictions to limit the locations of ADUs only, at least the word that it uses, only due to water and sewer capacity, traffic flow, and public safety concerns. The AARP Model State Act, we've looked at a number of AARP resources, does address this issue. And again, it's just a model state act, but that model act would prohibits requiring installation of separate water and sewer lines unless the ADU is part of new construction. So it's constructed at the same time
You say
as the house.
prohibited or permitted?
Prohibits. Prohibits.
Prohibits.
And again, this is just a model state act. So that's what the model state act recommends.
It's requiring some kind of development.
Yeah, prohibits local governments from requiring. It says that applicants can use a shared meter or install a separate one. And that Model State Act also says that jurisdictions cannot consider it a new residential unit for the purpose of fees or capacity charges. And it also says no impact fees if an ADU is less than 750 square feet. We'll see some examples from Maryland, I think other states that also have this cutoff based for fees based on the size of the unit. The Equity and Zoning Policy Guide from APA, I brought this one, I particularly wanted to bring this one up because, we talked about equity throughout our conversations. And while this isn't specific to ADUs, a recommendation it has is that reduce application or development impact fees for projects that improve neighborhood equity or opportunity. So, ADUs could be considered that, but that, when you're balancing interest and issues, that fees, the reduction or elimination of fees can be part of that consideration. And then we also looked at this one last time. A very good document was recommendations for Alexandria, Virginia, even though we saw last time that some of that is tied up in local litigation in Alexandria. But their recommendations were to reduce fees by allowing ADUs to share sewer and water lines with the principal structure. So we'll see, that's going to come back when we look at some Maryland examples as well today and state examples. All right, so as a reminder to those in attendance virtually or wherever, this is a link here to the full inventory of Maryland ADU ordinances. It's on our website. All right, so this one, I break it down between utilities and fees, even though there's a lot of overlap between them, not just today, but even with some previous topics we've looked at, particularly last time. So just summarizing Maryland, when it comes to utilities, most of the ADU ordinances do not address utilities specifically. Sometimes that lot size requirements are impacted by the availability of sewer, meaning they'll have a minimum lot size to permit an ADU if it's on septic, and and then a smaller minimum lot size to permit ADUs if it's on sewer. So whether or not sewer is there influences that minimum lot size. A couple of them do not, as we saw earlier with the AARP model, they do not count ADUs against density, but if it's connected to public water and sewer. Some require sewer service, but I was surprised when I went and looked at this, how few of them actually require properties that want to develop ADUs to be connected to sewer. And most actually prohibit separate connections for ADUs, as the AARP and others recommend. Most actually prohibit that already. We'll look at some examples specifically. So for Baltimore County, it prohibits separate meters if an internal ADU. All right. And then it allows separate meters for accessory ADUs, accessory structure ADUs, like a garage or a separate detached building, only if approved by the Office of Administrative Hearings based on specific findings of necessity. So you see, Baltimore County makes it hard for an ADU to have a separate meter. And I don't know the details of their Office of Administrative Hearings, but they definitely make that difficult. For Chesapeake Beach, they only permit ADUs on a lot of at least 7,500 square feet, but they also said it needs to be served by public water and sewer. For Indian Head, ADU permits require approval of the proposed method of water supply and sewage disposal. So they're making sure that, that's one step in the ADU approval process, is that has to be. All right, I've got a couple more examples from Maryland. For Caroline County, this one prohibits separate water and sewage facilities from the principal dwelling. Shall not have. TRAP specifically says that if the accessory dwelling unit and the primary have the same water connection, they shall not be counted against overall density. And then Talbot County, this is an example of what I was telling you earlier about how different minimum lot sizes apply based on whether or not it's connected to septic or connected to sewer. Has to be a minimum lot of 1 acre on septic and a lot of ½ acre or more on sewer. And then they specifically say, if it's 5 acres or less, it must have the same sewage disposal system. So again, another limitation on those separate connections. But if it's greater than 5, they would permit it. All right, let's look at fees here. Just like with utilities, most ADU ordinances do not address the fees specifically. Some base them on equivalent dwelling units. We'll look at an example later. Some require it if the unit necessitates capacity enhancements. So that would be part of the permitting process. If it's determined that the unit would increase that capacity enhancement, there would be a fee required. And then some exempt ADUs from school and other impact fees. I know we looked at an example from Coco by Design last month regarding how they were looking into that. Some of them already have this in their zoning ordinances. I will look at some examples here from Chestertown. Separate facilities are required if deemed necessary due to inadequately sized lines. Right, so that kind of gets back to that example or what I was saying earlier about if capacity necessitates it, then fees are required. This one's really long. I'm not going to go into detail about Smithsburg, but they specifically are considering, this is that equivalent dwelling unit requirement, that each apartment or housing unit is considered a separate unit, and a water allocation benefit charge of $2,600 per domestic equivalent unit for both of those is required. There's a lot more detail. I have to look a little bit more about how Smithsburg decided that that's the right amount of money, and that never changes. I would imagine that changes, but it is in their zoning ordinance. But that's an example of one that really delves into the details and specifically says how much money would cost, and specifically says that each ADU is considered a separate housing unit for the purposes of EDUs or equivalent dwelling unit costs. Last couple examples here, Frederick County. I just wanted to call out that they consider it's a special exception if it's 1,000 square feet or greater unit, and it's by right if it's less than 1,000 square feet. That we talked about special exception versus by right a long time ago, but I thought it'd be interesting to point that out. And then here's an example like we saw in AARP, ADUs 800 square feet or less are exempt from payment of school development impact fees. And then Anne Arundel, I know we looked at Anne Arundel a bunch of times, but the bill passed in January of 2023 exempted ADUs from development impact fees. Any questions about Maryland examples before we look at other?
Does
state
Anne Arundel
legislation?
County still require separate utility connections for their ADUs? Can you remember?
I don't remember. I'd have to go back and look at that.
I think not.
Anyone know?
No.
Most of them that I've seen actually prohibit the separate connections. That's what I've seen.
They made it as simple. as
Yeah,
possible.
they want.
I have a
These
quick
are-
question.
Yes.
I have a quick question. This is Lori Paris. I'm not sure if this was covered, so forgive me if it has been. But, and I'm not extremely familiar with the area, so it may be a very simple answer. But my limited knowledge and limited work in the water and sewer and dealing with going from category 5 to 4 in construction and the policy with respect to Maryland's position regarding septic wells, and how that really has impacted some construction because of the cost of connecting to the water and sewer lines. Was that part of kind of the overview discussion? Did we look at that? I may have missed it. But I just wanted to at least identify the issue or flag it. If we have, great. If we haven't, because that's something that often comes up here in my county. So I just didn't know. I'm just kind of throwing that out there.
I might want to drill down a little bit on your specific question. So you're saying the costs that Maryland imposes on various wastewater and water connections, be them on site or connected to the larger public?
Right.
Services?
It's not only the cost, but the requirement. And again, I'm not familiar with this area. And I've only dealt with a couple of projects where sometimes there's a requirement that depending on the building structure that you cannot do a septic tank. You have to connect to the water and sewer and the public and water and sewer, which is very costly. And so I just didn't know if we had discussed that, if that came up. It's just something that it's been on my desk for a couple of projects in the last couple of months. And I just thought, I would pose the question. I'm just not sure.
I know a lot of local health departments may require connection to a sewer system, depending on the size of the lot. A lot of local governments will require that as well, based on their own water and sewer planning. We haven't delved deeply into that because we've mostly focused on the zoning. But
Okay.
I know Susan looked like you wanted to say something.
Hi, Lori. In Prince George's County, you have your category changes when new development comes in, and I think that's what you're touching on for a moment. With the ADU, generally, these are already existing homes. So they're generally already serviced under WSSC. So it's not really a category change at that point.
Okay.
Okay?
Thank you.
You're welcome.
Any other thoughts on Lori's comment or suggestions? Okay, let's look at other state legislation. And as with the Maryland inventory, you can find the full table that we compiled with the help of Theo at that link on our webpage. Okay, let me catch up on my notes here. All right, so this again is split up. You can't see it in the room because this thing's in the way, but that's water and sewer. That's what it says behind it. And fees. So all of the state bills that we've looked at are sensitive to water and sewer limitations and permit local flexibility or restrictions in this area to some level. What I mean by that is none of them say you have to allow ADUs in well and septic areas. They all have some form of flexibility or areas served by well and septic. A few state that water and sewer requirements cannot be more restrictive than the existing water and sewer requirements for the principal dwelling, which has been a theme throughout our discussions on a lot of issues. Not being more restrictive for ADUs, lot size, and other things. One requires local documentation of a lack of capacity to prohibit ADUs. So while it does allow for a local government to limit it based on capacity, it puts the onus, the requirement on that local government to document that lack of capacity before it can prohibit. Regarding fees, many do not address fees at all, which basically permits them. At least my understanding, it doesn't address it. It's not restricting the local government from imposing them. Some state legislations prohibit fees, other base fee allowances on the size of the ADU. So if it's large enough, they permit fees. A couple grant explicitly or explicit enabling authority to jurisdictions to impose ADU impact fees. They say they enable jurisdictions to say you can impose fees on ADUs. And ADUs, similar to what we saw with ARP, ADUs added to lots versus those built as part of new construction, so built at the same time as the principal dwelling. They have variations on their requirements based on how ADUs are constructed. We'll get some examples here. All right, lower degree state preemption for water and sewer.
Could we jump back to fees for just one moment? So Montgomery County has impact fees per unit of roughly $50,000 per unit. That's the worst in the state, in my opinion. Baltimore County has impact fees of $15,000 per unit. And I think we ought to put in there that, at least I would recommend that there not be impact fees charged for ADUs. And if there are, they be really related to the lesser impacts that ADUs provide.
Hold that thought. We're going to come back to
Hold that
this.
thought.
You
We'll
can,
discuss more.
Sorry.
No, that's okay. That's okay.
thank you for sharing the specifics.
Wishing coming at us, but then we
I thought we
absolutely,
were all for fees.
not
Sorry.
quite.
No, we're gonna look at, we have to look at other states, when we'll look at both water and sewer and fees for states, just similar. So I used utilities when I was talking about the Maryland examples of using water and sewer here. It could be basically, for the purpose of this presentation, they're one and the same. So Washington, HB 1337, as a reminder for those joining virtually, you click the hyperlink, it'll take you to the bill itself. It specifically allows jurisdictions to prohibit ADUs on lots on septic. So it does says that it does allow them to do that. For Montana, which one we talked about last month, there's that one's tied up in litigation now as well. It enables jurisdictions to require water and sewer connections for ADUs. So these are the ones specifically saying that jurisdictions. All right, going up a little bit, the moderate degree, but I do want to stress that none of these are extremely heavy-handed on this topic, like we've seen in some of the others, and heavy-handed as in, top down, really restricting what local jurisdictions can do. So for Connecticut, the requirements related to water and sewer cannot be more restrictive than other requirements for well and septic areas, and cannot unreasonably withhold ADU, cannot be used to unreasonably withhold ADU permits. For Rhode Island, this one again has not been, at least last I checked a couple weeks ago, it's been passed by the House and referred to the Senate in Rhode Island. It hasn't become law yet, but we're still looking at it. Cannot require ADU developments to make water and sewer improvements unless required elsewhere in state law or regulation. We're going to move on to impact fees or fees here. Most of the state legislation uses the term impact fees. So moderate to high level, Colorado's, which didn't pass, but again, we're still looking at it as an example, did not pass. It permits impact fees not specified are Arizona, Connecticut, Maine, New Hampshire, and Oregon. Arizona is still being considered. And then specifically enabling impact fees is Rhode Island. Municipalities may exempt ADU. I'm sorry, they provide enabling legislation that allows municipalities or jurisdictions, all these states use different terms for their jurisdictions. It specifically enables them to exempt ADUs from impact fees. I'm sure Adam could describe this better than me, but all these have different, state enabling authority when it comes to how zoning fees happen in their community or in their jurisdiction. So some have to enable while others can be more silent on it. All right, moderate to high degree here. This comes with impact fees. So for Washington, they cannot impose an impact fee greater than 50% of that which would be imposed on the principal dwelling unit. California takes that square footage approach. if the unit is 700, if it's less than 750 square feet, they cannot impose impact fees. And otherwise, if it's greater than that, it must be in proportion to of its square footage in comparison to the square footage of the principal dwelling unit. And then you calculate the impact fees accordingly. And then Montana strictly prohibits impact fees on ADUs. I hear some public comments related to this topic. And I do this every single time. There's more, but these pulled out some of the big ones. As a reminder, I compiled the public comments as of yesterday and transmitted that to all of you. It's also posted on the website and they're linked down there if you'd like. So specifically, Baltimore has an aging infrastructure. There needs to be sufficient flexibility in any state policy legislation and ADUs to allow local governments to take this into consideration. If the goal is to keep the ADUs as an accessory unit within an owner-occupied home property, I would suggest that the requirements be that there are no separate utility accounts, which we're seeing is more common than not, and that this makes it less attractive for a non-on-site landlord. And they couldn't try to rent both units. When they say this is a bad idea, they're talking about ADUs generally are a bad idea. I think wastewater will become a problem and electrical hookups will be haphazard and dangerous. So this gets into that enforcement issue that we talked about multiple times. And there comes a long one last, because that's the most recent. So this one's more in favor of ADUs, don't change lot requirements, don't add parking requirement, don't include ADU and density calculations, all things we've discussed before, and reduce or eliminate impact fees. And then final, this is one I recently got here. I just got it over the weekend, all the details. I haven't really been able to dig into it, but this is specific. There's a long email. It's all included in what I sent to you. This is specific. It's comparing the cost between Montgomery County and Arlington, Virginia. And essentially it's saying because, it kind of gets back to some of what Lori was saying, because of Maryland's requirements that a detached ADU will cost somewhere between $15,000 to $20,000 more than the exact same size unit in Arlington. And these requirements are the same for ADUs served by public water, sewer, or via well and septic. But they gave a lot of detail about how particularly the well and septic requirements in Maryland drive the prices through the roof. So, as we normally do, I would like your feedback, or this is your time to discuss, either based on what we just saw, those examples, or your own thoughts related to this topic, legislative and policy recommendations, best practice, and if any additional research is necessary.
Just go back one slide.
Yes. I can keep it on whatever you like.
James had his hand.
Yes.
I do. Brother Griffin and I have been email friends because every ADU article I come across, I send it to him. The Alexandria situation says 2020, but as of March 14th, they just rejected a controversial Delray ADU. And the great thing about it is that it has a great picture of what they rejected. And it had to do a lot with where it was located, size, even though it had alley access, they still rejected it. And this is in the Delray area, which is over there by Potomac Yards. So I send Mr. Griffin lots of articles, but this was the one that I really jumped out at me because it actually has a picture
It's a two-story,
of what
right?
Miss Silk, yes. The idea that she has, grandma,
Right.
college, what have you, but I could see like 5 people there.
Oh, yeah.
Oh, easily.
Yep. Okay.
So I apologize. Easily. This is a big one.
David, and then we'll see if anyone's online that want to add to this.
Well, the bottom right one, I would vote for that. If what we want are ADUs, we need to make this as easy as possible. I would suggest, I've said this before, in our final report, we not get down too far into the weeds, but we give it just like this. Don't make this any more difficult than possible. And if we really want to incentivize housing and more housing, then reducing the various costs, especially the impact fees, which are really out of control. Baltimore County 2 years ago enacted impact fees, and over the last 2 years, they collected exactly zero because everybody would pay the impact fees. They went other places where there weren't impact fees.
Yeah, I've experienced that as a developer. Anyone online have questions, comments? Anything you want to add to this whole discussion on utilities and facility and fees? I don't think I see any hands up there, so we'll go back to Jennifer.
Yeah, I'm just waiting for her to come around too.
Just always like to try to make sure. I don't miss
That's what I'm pointing out. This is the part I really listen to closely when I'm developing your recommendations. So if you all wanna influence the recommendations I put in that document, now is your time.
So, I was the one when the question was asked previously about, have we talked about utilities and public versus private? That was me who referenced another plan I had done, a master plan I had written in which there was no development within areas not served by public utility, and that's something to consider. That comment in the upper left corner really speaks to it. We do have an aging infrastructure throughout the entire country, certainly in Maryland, and certainly everything associated with Baltimore City, Baltimore County, everyone's served through those reservoirs. The concern is something to be installed, and I know, David, you had mentioned earlier, do not take that off the books of saying we can't do ADUs in areas where people are on septic and well, but having something in there that talks about a requirement to ensure capacity.
Of course, you're absolutely right.
So, and that might be, however that verbiage is, and I went back to the resources and example slide you had where they talked about, on the California ADU handbook, only based on the adequacy of water and sewer service and the impacts on traffic flow and public safety. ADUs as a whole should not be impacting traffic hugely because we're not looking until we start building, separate facilities. If it's something within the existing structure, I mean, when you do traffic modeling, you're building those out in all of the different scenarios. But I do feel very strongly that with the utilities, our utility infrastructure is nearing capacity and or age limitations. And so having something that speaks to that is very important. But again, to David's point of not making things, we got to keep it simple so that people can actually do this and it's not yet another hurdle to jump.
I completely agree. I'm simply saying, don't prohibit it. Either the infrastructure is adequate or it's not adequate. If it's adequate, there's no reason to put on a extra prohibition. And sort of what you sort of said a little bit is our all mindset. We're all in growth management mindset. But if I correctly read the Sun paper 2 days ago, last year, Baltimore City's population dropped by 8%, and Baltimore County's population dropped by 2%, and also Garrett County. Everybody else went up. But in the Baltimore City, Baltimore County area, surprisingly, our population is going down rapidly, creating more infrastructure capacity, changing the last 50 years of the way we think about it.
Minus the age.
I'm sorry?
I said minus the age.
You're absolutely right.
Joe, can you advance the questions that we're trying to make sure we focus on here? We're gonna spend about, looking at our time once again, we're gonna spend about 5 to 10 more minutes on this discussion before we move to the April 16th meeting preparation. So I want to make sure everybody weighs in. So we're kind of on the first question. Now, what recommendations we've heard, a couple of concerns or recommendations that we should include in the report. Does anyone else have any thoughts or comments on that first question that they want to weigh in on?
Yeah, I think there are two things that I really like pulling out of some of the examples. One, I can't find it, the other one I can't find it. But the language in the Rhode Island that's bill that's passed the House that municipalities should not require permanent ADUs to make infrastructure improvements unless such improvements or modifications are required for compliance under state law or regulation. I think that's a great carve out because that will kind of get at some of the questions that have been raised around there being state limitations on, as our secretary likes to say, we've done a good job of restricting where we can build. So, ensuring that we're state law. And the second one, that I don't know where is referenced, was that, jurisdiction can only require water and sewer separate hookups when they've submitted some type of proof that they have some type of capacity challenge. That way there's some type of approving body, be that NDP or someone else, that has to, allow them to do that. On the questions of fees, I also really liked, the examples from, California. That it's prohibited unless, it's under 750 square feet. Otherwise proportional to the square footage. I think that's a great kind of compromise. I agree the impact fees, may be too high. But, I think as we've seen with some of the legislation this session, getting at impact fees is a very testy subject. So we don't really want to, we want to have a compromise if possible.
Great, thanks to you. Priscilla next?
So impact fees bother me too. One of my thoughts is that, first of all, we should be talking about a maximum size, but not a minimum size. And maybe impact fees could only be imposed if there's more than one bedroom in the unit. But I also think there's a big distinction between ADUs in the dwelling and ADUs detached from the dwelling. I mean, they are very separate situations. And for in the dwelling, I can't see any reason why there'd be any impact fees, why there'd be any utility issues. It should all be part of the whole house, just that's it. And I agree with not having separate utility hookups or anything for detached. But I think if we're gonna talk about impact fees at all, it should only be related to detached and only if they're over a certain size.
Great, thank you.
Doesn't make sense.
Great. That's what we need, your thoughts. I'm checking on the online again, see if see any hands up. I don't see any. Susan, do you see any out there? Okay, Deborah?
Yeah, just to piggyback on Priscilla, but when you're saying that, are you implying that the ADU that's in the dwelling does not have a separate cooking facility, or is it just bedroom and bathroom, for instance, or is it like a whole separate unit? Because the impact fee then would be,
No, 'cause
I don't
my
know.
understanding is that if it's in the dwelling and it's an ADU, it would have a separate cooking facility. But
Right.
you're not talking about huge spaces or, it's not a lot different than just moving more people into your house. It's just you also have a separate cooking facility.
Yeah, I guess I don't have a clear division in my head about why a separate structure versus an attached structure would be different from each other. But I also don't disagree. I don't know that an impact fee is that. I don't know that I would recommend impact fees in this case. I think the utility side of things will be taken care of by, as has been mentioned, if the existing utilities can handle this upgrade. I mean, just like an addition put on a house, if you can put another bedroom on a house, which is where I don't understand the conversation around sewer and septic and well. If it can handle it, it can handle it. And building code going through permitting process will determine if it can handle it. If not, you need to upgrade the systems. So I guess I don't see that we should be making distinctions about utilities. The utilities will make their own distinctions based on the design and build process, regardless of if it's a separate structure or an attached.
Yeah, this is another definition thing. Let's be really careful when we say detached versus attached. In all instances, we're talking about an independent living unit of sorts that has the full ability to really cook. Bathrooms, basically. It's
Right,
less-
'cause I don't think we can say that just because it's attached, people are going to be, maybe, that they're going to be operating differently than they would be if it's detached. Maybe they will be, maybe they won't be.
No,
But in
I-
either case, it's the same.
Yeah, I agree.
It's a separate structure.
Yeah, I agree. It's just one of them has party wall somewhere in the mix and one doesn't.
Yeah,
I mean,
yeah.
ultimately, exactly.
Okay, but I think they're two separate issues. I think there's a utility or an infrastructure issue, either it's adequate or it isn't adequate.
Yeah.
If it's inadequate, it has to be made adequate before you go forward. But I want to talk about impact fees, which some places in Rundle County, Baltimore County, Montgomery County, other places I'm not so familiar with, are a huge impediment to more housing, especially affordable housing. We are really, when it's all said and done, an advocacy group. And so because we're trying to promote ADUs. And I think this is a big issue. And my recommendation would be that we recommend either reduced or elimination under certain circumstances of impact fees. MACO and the municipal league, when it gets to the legislature, I'm sure will jump in, but that's for them to negotiate. I think we should advocate for lower fees.
David, I'll just respectfully, we're not an advocacy group.
Okay,
We are an independent group
Okay.
that are gathering the information so that we can provide recommendations. And I think while we all have strong perspectives,
Okay.
I just want to make sure for the purposes of the public.
you're absolutely right.
Yeah,
I'm
and
sorry.
so after we finish our report, if you want to be part of an advocacy group to advance it, you are totally free to do that. I just want to make sure people know that we are not taking a position yet. And probably won't, we will listen to the recommendations, so yeah, I just respectfully say that. Question number one, any other inputs or thoughts?
I do,
We've got a few, and then we've got the next.
Dan Hoff sent me some,
Oh,
he could not be here.
Okay,
That, so, I mean, let's see what he, he very strongly believes that ADU should not require additional hookups, because this would make it much more expensive. He also thinks, that ADU relation to this, and I think we saw it earlier, that they should not be subdivided, and that this could potentially facilitate that, so, shared connections will prevent them from being subsidized. He's against impact fees, generally said. And then he connected it to APFOs. He said APFOs related to schools should not be applied to ADUs, which we've looked at before. But he said he did express that if it's water and sewer capacity, that should have that context specificity, and that there may be some times where that applies. And I think some of the other folks have said the same thing based on adequacy of infrastructure, adequacy of capacity. So I just wanted to share his thoughts. He wanted me to share it.
Well, that raises an interesting issue. You can't subdivide. Can you create a condominium with the ADU as one of the condominium units?
then you would be having a separate ownership, and I don't believe that that's the intent of
Well, I think we
ADUs.
need to say that.
Okay. Because, yeah, the minute you create a whole separate titling, who's that? Separate titling, then all of a sudden you are not a property owner creating another dwelling unit, you become two property owners.
Well, then I think we ought to say that.
This is something we discussed in the very first meeting when we were going over what the bill said. And I know Secretary Flores said earlier that we can go beyond what the bill says, but the bill did say that we're to examine ADUs on owner occupied land, implying a lack of subdivision in the bill itself.
That's a whole other.
Yeah.
Yeah. Okay. The second question really, I think, is related to the first in a lot of different ways, but in terms of best practices in this particular topic, I think it's, kind of hard to separate it necessarily from the policy recommendations, but does anyone have any particular thoughts on this one? I think it's related to the best practice of the policy that we all reference. There's an item in the chat. I want to make sure we're capturing that. Is there something?
My colleagues are helping with the chat. I'm not sure if it's a task force member or member of the public.
Okay. Someone just let us know if we need to respond. So the last one is research. I want to touch on that before we move into the next segment. I think on this one, and I'm going to go ahead and weigh in on, see if others have thoughts in terms of additional research. I know my MDP planning team is much more versed in this than I am, but in terms of this issue of capacity, we do keep a pretty good understanding of, sewer limitations, capacity. I mean, I think that's a really difficult issue. Because some jurisdictions will say, well, we're at capacity when we're at 90% because it takes so long to expand or upgrade or do anything with capacity. So we have a real chicken and egg problem, quite frankly, because if we were to say that that is a major determinant, we would essentially be potentially stopping growth in a lot of Maryland. And so which comes first, right? And I think it becomes a little bit of a dicey issue, and I don't have the answers. I know I've just delved into it, and I've delved into it both with MDP and as a farmer developer. So I don't know, I guess I'll pose the question initially to Joe, because I don't know, is there some additional data or existing mapping or anything that we have that we provide to sort of just shed more light on this issue of available capacity and where that would become prohibitive, because it would just rule out anybody allowing ADUs versus, that maybe just isn't an issue.
But we definitely don't have any mapping related to that. We do have mapping on existing sewer service and planned sewer service and not planned sewer service. That's the planning side of it. We become aware of and engage with capacity limitations, requirements, expansions when we review water and sewer plans and their amendments. But the organization that's going to actually have those numbers would be the Maryland Department of the Environment. This comes down to we saw earlier that Smithsburg example on equivalent dwelling units and, jurisdictions, or I'm not an expert on this, but it's actually the actual treatment plants have they assign more to the treatment plant to a jurisdiction. And Amy, I know Amy's well versed on this. If she might be able to help me as well. But those EDUs are assigned to the wastewater treatment plants. And then that is what's going to restrict capacity. And then there are MD has a lot of funding sources that can help expand capacity, but a lot of it has to do with, some of it, especially drinking water, has to do with the actual what's available in the ground. Carroll County, for example, is very restricted with its drinking water because what it has access to. So there's physical limitations that even increase in infrastructure aren't going to help, or only help to a certain point.
I think this is a circular thing that we might want to ensure in the report that we've at least addressed. I mean, because we can talk about, well, if it's adequate capacity locally or whatever, but I think having a little bit of a reality check of what does that actually mean or what would be required, because that's a big issue, and the impact fees relate to that, because a lot of folks are trying to fund their poor infrastructure by increasing the rate of their impact fees, or basically stopping development in some cases that only the rich can afford. So there's a whole lot buried in that I feel like we need to shed a little bit of light on. I see a whole bunch of things happening in the chat here. Maybe people have some answers there, but I want to throw that out there as a potential additional, if not research, resource or information on this.
Most jurisdictions have some sort of inadequate facilities
They all do.
program. I don't know that they all do, but lots of them do.
But it.
And most of the programs have a map of where your incapacities are. So jurisdiction by jurisdiction, we ought to be able to get that.
We can, and the question is the interpretation in terms of intention to upgrade. They don't want, or there's a lot of variabilities there. So Susan, maybe you can help.
So in addition to the water and sewer, which we've been talking a lot about, there may be a lot of opposition to ADUs due to school capacity. And school capacity was analyzed by Montgomery County. They're keeping track very tightly of how many new students are coming out of lots that have ADUs. And they're finding that there's no change.
Right.
So there aren't a lot of students coming out of, including the primary dwelling unit. So they combine both the primary dwelling unit and the ADU unit, and they're saying there's very little to no change in student impact. So that's something too that we might want to look at, or at least report upon that from Montgomery County. I think we have some of that in writing from them.
So that would be a potential statement we could make, with at least that one example of debunking perhaps the notion that this is gonna have an impact on schools.
Yeah. Because school fees are often very high.
Yeah,
You know, $15,000 impact fee is not unusual for a new constructed home. 10,000 maybe inside a beltway. You know, in certain exemptions, but yeah, that's gonna be an issue for people.
right.
I want to ask my colleagues who are monitoring the chat, if any task force members have put something in the chat that they would, we should allow them to go. Or we'll save public comments for later, but any task force members? I know it did jump from like 5 to 19 in a few minutes.
Rebecca, one of my concerns isn't that they're necessarily the growth that we want in the housing, it's that it's not permitted growth. You know, people are sticking these things in their houses
Oh, right.
and they're not permitted, so then you have the electrical issues, you have the plumbing issues, you have all kinds of issues when nobody's inspecting these swellings. And that's a big problem. I'll tell you something interesting. We have an AARP employee who's about to retire and her house sold much before she put it on the market. So she's looking at renting an ADU for a while. And there's some website that has hundreds and hundreds of ADU rental units in Maryland. Where are all these units? These are units that people don't know about. They are just rental. They are units in homes that are for
On the
rent
radar.
to the
But
public
on the radar.
and they're on
Okay.
websites. So
Yeah, interesting. Okay, we need to wrap up this segment, because we still have one more thing to do before the public comment. Let me just get any new comments that we may have, James.
Yeah, real quick, I want to address it. One of the reasons is because a lot of jurisdictions, including my own, were waiting for Maryland legislation along with this committee to make recommendations. Then they were going to move forward with recognizing those plethora of ADUs, if that makes sense.
Interesting, good.
So, yeah, so we have them, we just don't know where they are because we're waiting for somebody to tell us what to do.
and they're gonna be very reluctant to raise their hand and say, I have an ADU.
So one
Because
thing-
now you're gonna come in and legislate.
So different topic, but another thing to consider in our recommendations is the whole grandmothering, however you want to put it, of existing.
Well, it has to be grandmothering. So
Yeah.
there are-
We do have a recommendation. We do have recommendations in there regarding amnesty programs, which we've discussed before. So I encourage you, if you're interested in this idea, and that's not one and the same as grandfathering, but I encourage if you want to talk more about this, please comment on the amnesty program recommendation that would have been from the design and building code, I think.
Okay.
I think the January meeting.
Okay, let's move to the last segment. Was there anything in the chat that we need to recognize, or was it more just some informational stuff back and forth?
Somebody just asked about amnesty programs. I think,
We can read
this, I think, yes, I'm just looking this up, so I don't have the history.
Okay.
I don't have the history here. It looks like Chuck I know is monitoring it, Mike.
Chuck has his hand up. Chuck, do you want to read out anything we should be?
No, I think all the comments that we've seen so far from the attendee public. So
Okay.
I've not seen anything. I know Amy Mordock had her hand up at one particular point and took it down, but I don't see any of the comments from any of the guests of the panel, of the committee members, task force
Okay.
members.
Thanks, Chuck. Okay, we're gonna move to the last segment then. Just for almost that time.
I want to make sure, when we come back, we'll make sure Amy has a chance to speak, because I know that Queen Anne's County has particular work in this area about capacity, and she can inform us, but we can come back.
Okay, let's just make sure we touch on this next topic for the comment if we can. So we've been alluding to this all along. We did extend the meeting time. I hope everyone is able to adjust their calendars and be with us for the full 4 hours. I think we're gonna need it. We also are gonna bring in lunch. So we'll be getting something out to you about that. But, you know, when we looked at it and everything we need to try to bring together, we hope that as we've been going along and, you know, reviewing the previous meetings, recommendations, et cetera, that everybody should sort of be moving along with us at this point, but there's still gonna be a lot of work to do at the last meeting. And so I think we'll be setting up, you know, a meeting framework for those 4 hours to make sure they're really productive and we come out with some really good outputs that we can all feel good about. But Joe, do you want to highlight specifically any aspects of this that we need to get ready for?
I just wanted to kind of go over what we were planning. My original plan or what I have in mind so far. It probably will change as I sit down and start to write out the agenda. This is what I was thinking, and I'd like to feedback from you all about what we're going to do at April 16th, yeah, with the extra hour. We already talked about it, the recommendations prioritization. So I strongly encourage you all, especially once I add the recommendations. Do you need this yet? Yeah. So once I add the recommendations from last meeting and today's meeting, to be commenting on that document that I sent you all. So please let me know if you were not able to access. I sent it in late February with some suggestions on how you can comment. That will be very important. And if you're not able to comment on it, please make sure you go in there and familiarize yourself, remind yourself, because we've talked about a lot of stuff, many pages of recommendations, and it's easy to forget. I mean, I wrote them all in there and I forget what we put in there. But please go familiarize yourself because there's a lot of stuff in there. So we're going to be working on that. As I mentioned, the table of recommendations we're going to be developing based on community context. We're going to be looking at the housing market analysis. I introduced Fami last time. She's working on this. Pitch completed a literature review, but we're also, if you remember, I presented the housing market analysis plan at the November 28th meeting. So the literature review is just one component of it. The other things we have specific, all the focus group and panels, the first questions in each one of those are designed to inform the housing market component. Also some survey questions. And then Fami, Susan and Fami and I have been talking about Montgomery County's mapping that they've done. And we're going to really hone in on what we can see and Montgomery County's permitting data to help inform that market analysis. We were never able to get widespread permitting data from around the state. It's just not available. Could potentially be a recommendation coming out of this. If we really want to monitor what is or the impact of ADUs, we need that permitting data. But we're going to look at that as a representative sampling. And that was another language that was in the bill, representative sampling. So we're going to look at the housing market analysis. I've been compiling all the public comments over time. Each time we've met, I've added more. We've looked at a few examples based on the specific topic, but I'm going to be doing a deeper dive into the public comments, organizing them around topics, themes, big ideas. We're going to be really looking at those more closely because we've received a ton of public comments, both in the commenting form, also in the chats at each meeting, but also we've received a lot of separate emails as well and specific letters. We'll be looking at those. We'll look at the environmental organization survey. And then I just wanted to remind, I mentioned this earlier, but other topics that have come up but we haven't developed specific recommendations related to them because they were not within the structure of the research plan that we established, but we want to make sure we at least want to think about or decide whether or not we want to address them, right? Some of them come up like ADUs in growth areas. Growth areas is a very specific in Maryland. It's very, there's a lot of things in Maryland law and Maryland planning that has to do with growth areas. Talked about covenants today. We don't have any recommendations about covenants. So there's something to think about. Adequate public facilities, talked about them. Short-term rentals, it keeps popping up. Anything about incentives or local technical assistance programs. Again, you're not going to see those in zoning ordinances. Just general processes and programs. Owner occupancy, familiar relationship requirements. Those have continued to pop up, but have not been a specific topic. Equity, affordability, subdivision of ADUs. I wrote this down. It came up again today. And then anything about rental licensing programs. So I'm going to be reminding you all about those, and we're going to want to decide, do we want to venture into some of these areas or do we not? And if we do want to venture into those areas, what are our recommendations? So I'll be bringing those back to your attention.
Very clear that we will not venture unless we finish our first homework assignment.
There's a lot of recommendations already without those topics that I need you all. Really
focus. To ensure we come out with clarity specific to the assignment, putting on my professor hat. So we're gonna be real careful about that, quite honestly. I mean, we can do a separate summary of information or something, but we've got to come out of this with our clear recommendations. So I just want to be, as chair, I may invoke some abilities to keep us focused in that regard.
Well, can we make a list and then
Make a list.
down them and yes or no?
We'll make a list.
Okay, good.
Okay.
Well, I can, if you like, I can share those topics I just read.
Yeah, I think we should share, and I'm gonna be doing a deep dive with staff around organizing our 4 hours to make sure that we may even need to send you some initial polling ahead of time or anything to help us zero in on, zeroing in on the things you really need to still work through. There may be some things that, they're pretty easy. And so trying to be as prepared as possible. The other thing I'll be doing is there's been, I think, really good participation of our task force for the most part throughout. And there's only a couple of folks that have not been here quite regularly. I'm gonna personally reach out to those folks. And I'm also gonna just keep that, we are asking everyone to come in person for this. To ensure that we really can have, I think, dynamic, I understand there might be exceptions or issues, I'm just gonna really strongly encourage that. And then I think, organizing the information so that it really becomes categorized. It won't be perfect, but at least it's in categories, so we can, I think, address the hot topics, most, and then stay focused and get back to the bill, because everybody's been very passionate, very informative about this. I just want to make sure we get back to what we were tasked to doing and make sure we address that first. And then we can sort of circle on some of these other items, because we'll still have May. Just want to make sure we come back with that. So other thoughts or questions or inputs or things that you all would like to see on the April 16th meeting?
Just a suggestion,
Yeah.
it's okay perhaps for those other topics, if you could send out a poll that we could respond to categorize what we care about most.
Right.
That way we avoid lengthy conversations.
Or me being, thrown out as chair because I sorry. I think a poll of some type, particular to that, possibly to other things, we're gonna have to take a look at and sort of see if we can.
Maybe you should bring a gavel or a bell.
There we go.
Time's up.
There we go. I think my wife said this
Gavel, yeah.
50 years ago.
Is it the last meeting?
Yes.
Thanks.
And we're gonna vote on something final.
Yes.
Well, the idea is maybe to have a draft report, or at least as much of a draft, we'll have a draft report.
Yeah, you have to have.
To Matt, so May is gonna be mostly in
Tweets.
feedback on that draft report.
But it's yes, no, or amend.
Yep.
Yep.
We should be down to really, that's why April is so critical. We had to walk out of the room with April, with pretty good consensus. Yeah. Other questions on this, thoughts, ideas?
So we are meeting in May?
Yes. We have to vote in May.
That's the final vote.
Or
You have a
can
date?
Mail it in. It's in the other
Oh, is
calendar.
it?
It's May 20 something, I think, it's the third Tuesday.
No, if you'll get the report in advance.
We're not meeting in
You
June.
can always, and when I say vote, I mean, we're not a authority of any kind. I just want to make sure that everybody's with us on this. But you'll get the report in advance and you can weigh in, through mail or something, but the big meeting.
If I'm not too busy. I'll-
Yes, well, springtime in Paris, right? But the big meeting's April. And hopefully, that, very good. We've got to roll into public comments. Any other, okay, let's go into public comment then. And see if we have anybody.
Well, we have one member of the public here in person, get priority, Jeff, okay, speak.
Just,
Come on forward or
very-
stand up, whatever.
very
works for you.
briefly, I just wanted to. The slide that had the.
I'm sorry, can you
Oh,
introduce
I'm
yourself and your affiliation?
Jeff Delmonico, Howard County Planning and Zoning. So the slide that had the task force doing the breakdown between zoning, building codes, just wanted to add, I didn't see anything in there about permitted uses, accessory uses, just uses in general. I think that's just an important one to add in, whether it be a conditional use, accessory use, how these ADUs would go about. Talking about zoning, being in planning and zoning, I just know subdivision land development regulations might also be something that these recommendations might be kind of getting into, so just keep that in mind. And then at the last year's National Planning Conference, there were planners from Tulsa, Oklahoma, who came and spoke about recent ADU regulations that they brought forth. And one big takeaway they had at the end was just talking about how many, many of the communities there did start to complain about the aesthetics coming down. So namely, the thing that I remember the most is some community members complaining about parking pads being just like concrete parking pads going right up to the street and taking up the full front yards of some homes. So their takeaway at the end was about maybe making recommendations for design guidelines and something on that. So just throwing that out there is something that I'm starting to see.
Thank you for being here. Thank you for sharing. I really appreciate it. Thank you so much.
I have a quick question. So what you're saying is to address the two off-street parking, they just paved over the front yard?
So it appears.
That's a good idea. Let me. Who needs
That
grass?
was a solution that certain homeowners decided to utilize and take up. And so I think Tulsa planners started saying, well, wait a second, maybe there's more that we could do to try and address some of those challenges.
To pave over the lawn and just great. Good idea.
Talk about it, all right? Yeah.
That's true.
Thank you. Can we have comments online? Chuck, or who's
My
monitoring?
colleagues, if somebody online says that they want to not just put in the chat, actually be unmuted and speak, let us know.
Chuck, are you monitoring that?
Yes, there's one, I think you can, Eileen Schneider.
Hi, how are you? My name is Ileana Schinder. My voice is a little taking because I'm getting over a cold. I put a few comments about consumption of energy and water. But one thing I want to point out at this stage of the task force is try to stay away from subjective topics such as character or aesthetics. Anything that you recommend in the task force, make sure it can be measured, because the only thing you can enforce is things that can be measured. The example that the previous neighbor just brought up about parking is because the local jurisdiction probably hadn't measured how to control lot coverage or how much can you pave, how much can you cover. So all the elements that you recommend, make sure you focus on how can these be measured, how can these be implemented. If there is no yes, no, or a rate of like lot coverage or things that is a number, it will be almost impossible for local jurisdictions to implement or even take. Again, I brought in the previous meeting, I'm an architect, I do a lot of additional dwelling units, Montgomery County, Washington, DC, Arlington. I wrote a book on the topic, and the elements that you're trying to bring up and recommend are repetitive throughout the nation. I'm glad you're already making a huge difference between zoning and building. But also, I think the next step would be something subjective versus objective. If the recommendation you're making can be measured, it can be implemented. If it's something subjective, such as building character, it cannot. Things that are easy to measure is ages and sizes of trees, for example, lot area coverage with permeable surfaces. Those are things that are very, very easy to measure. You can stop somebody from building an ADU if they're going to pave their front yard, because that is easy to measure. But you can't ban it unless you warn them that they need to allow for certain greenery on the site. So those are my two comments. I see a huge difference between the previous meeting and this. I'm really, really happy to be able to listen in. I wish I could be there, but I don't think anybody wants me near anyone else these days. Like I said before, I'm always open to share what I know and my experience and how my projects have tested zoning maps in the region and what things are easy to do and what things are easy to get away with. So I remain open if anybody needs to reach out.
Thank you so much for being here. Is it Elena?
Ileana.
Ilana, thank you so much for being here. I really appreciate not only the work you're doing, but to comment and give us your insights. Thank you. Chuck, any others that are asking to make public comment?
We have one for Greg Cantori.
Greg. Hi, Greg.
Hi there. Can you hear me okay?
Yes.
Great. I want to just reinforce what Elena just said. She's been fantastic in the ADU movement in our state, is a renowned expert on the actual implementation of ADUs in real life. So when we're talking about this on a theory recommendations basis, that's one thing. But what we've learned in Anne Arundel County is that passing the rules is not enough. So we're working on ADU 2.0 in Anne Arundel County after passing the most progressive rule in the state of Maryland. So what I say by most progressive is that we followed California's recommendations pretty much in whole, and also the AARP's best recommendations. And we got it all passed at 7-0 with the county council, which was remarkable. The most conservative and most liberal council members all agreed that this was a great thing to do. So with that under our belt, back in April of last year, we only built, I think we had 13 actual ADU applications and only built 2 or 3. And what I'm pointing out is that we need to have the most progressive recommendations, because even with that, you will not see a proliferation of ADUs without additional work. And that's where 2.0 comes in. And 2.0 means things like an ADU navigator that helps person go through the entire process from start to finish. It means having low and no interest financing along the ways. And the FHA, you may already know this, the FHA and HUD already has a really remarkable program now where 75% of ADU rental income will qualify towards your purchase requirements or your financing requirements. So that's amazing. And 50% of future ADU rental income. So if you don't even have an ADU yet and you want to build one, FHA guidelines will allow the lender to apply 50% of that income towards your qualifying income. And that's critical for our lower income homeowners. So I just wanted to point that out as well. So ADU 2.0 includes the financing piece, includes the navigation piece, and then it also includes a piloting piece where we need to actually see what it's like on the ground to go through the nightmarish process of applying for the permits, getting the design done, getting the financing in place, getting the construction done, and actually managing the unit once it's built. So just wanted to point that out, is that Anne Arundel County is ahead of the curve. And I also want to point out that Prince George's County is behind the curve. They have an outright prohibition on ADUs, and I find that very regressive. So hopefully our state rules will change all of that. Thanks very much.
If I could ask the question, if you could simplify it a little bit, what do you think were the largest obstacles that you only had 2 or 3 ADUs built?
Very good point. I forgot to mention the marketing piece. The fact is, vast majority of people don't even know what they are, don't know that they're even allowed or legal if they do know what they are, and don't have any place to turn. Where would they go to have one built? So those are the upfront obstacles. The next one, of course, is the financing. They can be very expensive, and the whole process can be very disruptive. So all of those things, the permitting process through Anne Arundel, even though they have the law in place, is complex and uncertain because they're trying to come up with the new rules under the new law. And so there's a lot of questions within the departments themselves about what to do. So that's a really great question, is why aren't they building more? That's probably the preliminary. I also mentioned Anchor Tiny Homes. That's a franchise that's spreading throughout the country, will be coming to Maryland. Their objective is to have a one-stop shop. So ideally, what we would have, like in Anne Arundel County, is a process that's as easy as a solar panel installation, where you come in, you sign on the line, and from soup to nuts, they do everything. They help you with the financing, the design, the building, and implementation of it. So hopefully that'll create some new units.
I didn't hear your first sentence. You said tiny homes. Who is that group?
Oh, it's called Anchor Tiny Homes, and they are the first ADU franchise in the United States.
I think they've been to some of our meetings early on.
Yeah,
Thank-
they're,
Can I ask him a question too?
Yes,
Quick
thank you,
question.
Greg. One more question. And I want to make sure, well, let me do this. Do we have other people waiting to make public comment?
Yes, there's one more person.
Okay, okay, I want to make sure we get that person in, but Priscilla, go ahead and one more question. Greg.
Like, does the Anne Arundel bill override the CCRs for the homeowners associations?
no, it does not.
Is that gonna be part of your 2.0?
Yes, it is. Good
Okay.
question. Thank you.
Thank you.
Okay, thanks, Greg. Chuck,
Thank
who's
you.
our other public comment person?
Maria?
Marie.
Marie.
Hi, Marie. Go ahead. You can unmute. Someone can unmute her.
She should be unmuted.
There you are.
Okay, thank you. This is Marie Dias with Dias Real Estate Academy. I teach real estate. And I had a couple of questions. If the state legislature passes laws allowing the ADUs, can the counties and local legislatures pass laws more strict than the state? And then will manufactured homes be allowed? And do you have information about Prince George's County recommendations?
Okay, 3 questions in there. So I'm going to defer to Adam.
On the first
We
one,
don't usually do Q&A, but since I think this is our last public comment. Chuck, is there any other people in the queue for public comment?
No.
Okay, I think we can do a quick response, Marie. I appreciate your questions. And
quick
quick
response.
response.
It depends on how it's written. Yeah, the legislature could write it in a way that prevented locals from doing anything other than what the state provides, but it could also make it more flexible so that locals could do something more facilitating ADUs.
Yes.
They could do that too, but that would be kind of
Yeah.
in tension with the whole policy.
It depends. There's so much of it depends
Yeah,
there,
it's
I
how they
think,
write it.
yeah. I think your other question specific to manufactured homes, based on the definition, the HUD definition of manufactured homes, in terms of basically being fabricated off-site and brought in, I suppose to some degree, the tiny home approach addresses some of that. And I'm going to defer to Theo on this one to see if there's anything keeping us from.
So, you know, there is existing legislation that's making its way through the General Assembly called the Housing Expansion and Affordability Act that explicitly addresses manufactured housing, permitting it in all areas that are zoned for a single family. That is going through the legislative process, and we'll know by April 8th, I believe, what that form takes.
Great, thanks. Great succinct answer. And then in terms of Prince George, I don't know if we can delve into that, Marie. I don't know if Joe or Susan might have a quick response to the Prince George question.
Prince George's County is a local authority on their planning and zoning at the county level, except for the city of Laurel. And we will not be addressing individual counties as far as I know in our report.
Yeah, we did put an inventory together of ADU ordinances around the state. And Prince George's is
They've
prohibited, it's gonna be blank.
Right, so
we
we
only-
won't, it just prohibits ADUs, period. So I think how that evolves to be determined. Thank you, Marie. Thanks for being
I
here.
don't know if Lori wants to say anything as a representative of Prince George.
We have I'm sorry, Laurie.
Lori, I want to make sure we're not speaking for Prince George's when we have the legitimate article here.
No, I agree, that, Prince George's County, is restricted with respect to ADUs. So I haven't heard anything that, isn't accurate.
Thanks, Laurie. Okay, well, that's gonna close our public comment section of our meeting. Thank you all for anyone that is out there listening in. I think you've got a pretty good sense of where we're going. We've got a couple more meetings and report to come, so stay tuned. And of course, we can be posting on our webpage also, meeting materials and whatnot. So we're gonna go into the final portion of the meeting where I always like to do a closing round, but Joe, do we have some specific things you need other than my needs?
No, I mean, I'll leave up the next steps. I don't need to go over all of them, but I'll just a reminder, we have the 4-hour meeting in April. And I'll leave that on the screen. That's what we'll be working on, but that's it.
Hey, great. Well, Good meeting as always. I always appreciate all of you. I want to do a quick closing round of any kind of concluding thoughts, if any, from today, so that we make sure we grab everybody. And I'm just going to go in reverse order of my sheet here. So I'm going to start with Isabella. I think I saw you come in. Are you out there? I guess I'll sign on briefly and then maybe sign back off, okay? I do not believe Lisa's with us. Lisa, let us know if you are. Okay, we're going to Jennifer.
So I've written down, so I wouldn't forget. Really nothing new to add, but wanting to circle back, especially Joe, as you said, you listened to these comments. So I want to just really emphasize level set definition as something we absolutely need. I know we've talked a number of times with the utility throughout this entire process, but just making sure that we understand what that constraint is and how we address it, even if it's handled already through, I know Deborah, you've mentioned, you know, how it's possibly already handled. I just think that's such an important component to address, because, I mean, you can look at the ASCE report card around the country of our infrastructure and where we are. Keeping it simple of really understanding, this kind of comes back to one of our last comments publicly, but understanding what it is, how to apply, how to finance, how to enforce for local governments and permitting agencies, like making sure we don't put something that's so over the top that nobody is ever going to be able to use this. And then this is one that I said early on, and I think for April under that other category is what are the unintended consequences of what we're doing, especially when we get to selling the property and the secondary market, and what does that look like?
Okay, great, thank you. Okay, Mandy.
Yes, the Maryland Coalition of Interior Designers, we're currently reviewing the draft recommendations. We plan on sharing our comments shortly prior to the meeting. We'll have them shortly. Really nothing to add about today.
That's a really good point. If any of you are representing associations or anything, and depending on how you operate, if there's a need to circle back, that would be the time to be doing it, because we will be looking at UB to carry forward that representation, if that's how I know I've sat in those situations where it's like, am I a representative of, or am I simply here giving that perspective? So maybe any of you that might be in that situation, just get clarity of what you have the ability to weigh in on. That would be really good. Great, thank you. Priscilla.
Said far too much today, but I will say again, that I think that when I hear comments, see comments, everything else, it just seems to me that people have in their heads their own vision of ADU. And most of the time, I think they're thinking of detached units. And I think we just need to make clarity, repeating over and over again, the definition we're working with, and that it's detached and included in the facility. And as far as what AARP thinks, we all know, because it's all over all these slides. But anyway, that's my biggest concern. I don't want people confusing. I don't want them thinking that it's just the detached units.
Gotcha, thanks. Okay, Deborah.
Yeah, I don't have a lot to add. There's a lot to take in from today's meeting. It was a lot of information. I'm going back to the very beginning about the parking discussion, and I feel like we kind of glossed over it. I'm hoping that we can maybe spend a few more minutes on some of those things before making recommendations, specifically the one space versus no spaces. And I do appreciate what Priscilla just said. I think maybe it is also worthwhile us considering if we're making any recommendations that do in some sense become restrictive, do they prevent the attached unit? You know, how does it impact both scenarios, the detached versus the attached? And I totally agree with you, Priscilla, that I think we all are thinking of this in terms of a detached unit, but the attached unit is always going to be the more cost-effective and probably simpler solution to move forward with, or that most people would move forward with. So it's worth just having a mindset around those things. Anyway, thanks everyone. This was a great discussion today.
Thanks, Deborah, and
And I also will be sending it to AIA for their recommendations
Oh,
as well.
okay, great, thank you. And I do think, we're gonna have to look at, some type of a polling or something to sort of really be able to zero in on the topics that we feel are most critical to, circle back, because we didn't really get enough time to discuss, and so we'll try to help sort that out before April, a lot to do before April. Quinn?
I've got no further comments. I appreciate the discussion today.
Thanks, Quinn. Appreciate you always being here. Thank you. Tiffany, I don't believe joined us. So on to David.
I think we're doing great. I think I've made my views known. The rubber hits the road next month. I would certainly do the poll and would never get through it in 4 hours. On May the 3rd, I am doing an event called Land Expo with Secretary Jake Day of HCD. Madam Chair, you're invited if you would like to talk. I'll put you on the program. I'm doing the keynote, which is why America is underhoused and overparked and what to do about it. Secretary Day is doing the luncheon talk. It's all morning plus lunch at Laurel Racetrack. If anybody would like to come, I'll get you comped in. Just let me know. And I will be presenting where I anticipate we are at that time. This is May 3rd. We will finalize till later in the month. If you want to go, just let me know.
Send me the information.
That is, thank you for that, and I'll do another plug, then move on. May 2nd, we're doing a Smart Growth Summit, National Center for Smart Growth, so it's an all-day event that day.
And where's that?
It'll be in Annapolis. We'll be sending stuff out on that, but let me
Okay.
keep going around here. Let me see, Councilman Hoff, I don't believe joined us. James.
I don't have anything. I think I've said it.
Oh, we love your comments. You give us reality.
Well, I do one thing, grand person. I think we should say grand person, right?
Thank you, I agree. Thank you for that. I appreciate that. Okay, Amy.
I think this has been a great conversation. I don't have anything else to add, and I look forward to seeing everyone next month.
Great, thanks, Amy. I would offer to carpool from the Eastern Shore, but I never know where I'm gonna be the day before. Okay, Lori, any comments?
No, I just want to say, I agree, it was a great conversation. And I do want to make sure that, I think the big thing for me was really just narrowing down what that definition of an ADU, attached, what that looks like, because I think that's going to guide kind of the response, I think, with respect to any recommendations from different counties based on kind of their priorities, rural, urban, or suburban. But it was a very good conversation today.
Thanks, Lori. Thanks for being here. Theo.
The only thing I'd say is just want to thank Joe and the rest of the team for the amazing job they've done all of these. And really exciting experience. And it's been put together really well. So thank you for all your
Thank you. I agree, totally agree. I wish I could take more credit, but I don't. Great team. We always review it before everything goes out, but I think, yeah, I'm very grateful for that. So I'll just close this out at 12:28. I think this group has just been tremendous. I will, like I mentioned earlier, take on the task of reaching out specifically to people who I feel have been not here because the risk we have is folks coming in at the end that maybe haven't participated along the way, which is a lot of information. So I will personally reach out to folks that maybe have not been as able to attend, and some of it's just session. We're in session, so session will be over. And so, but we do want to ensure we get everyone's input and stuff. And I think the biggest thing, myself included, is to just do our homework. There's a lot of information. It's easy to sort of forget that we've been meeting since September. So it's all there. Just try to find time, like I said, myself included, to do a refresher, go back through what we have, what's been continuously compiled. If you're working or here representing associations of any kind, make sure you're checking in, making sure that you can really get to this end point that we're trying to get to. And we'll do our best to try to be extremely well organized going in to, if you cannot be here, right, Richmond, on the 16th, please let us know and we'll try to work out some kind of way to ensure we get your input for that meeting. I'm hoping maybe lunch will help, but we'll do our best. I think that's it for me. I'm grateful for this group. I think it's been a really great process and look forward to see where we ending up. So all good. Thanks everyone, and thank you all online. Thanks for being with us, particularly all the public that I know have continued to stay engaged in this process. Thank you all. Appreciate it. Have a great day.
Great job.
Bye.